That works. I'm curious, is there a website for the rent control board that someone can sign up on to get automatic notifications about meetings or anything else that's happening?
Absolutely. You can go to our website and right at the very bottom of our homepage, it says sign up for electronic communications. Click that and you can just say what you want.
Okay, so you could choose to get all automatic updates. Right. And what does that say?
It's on the, I can show you here.
Okay.
I'm messing with that. 24 seconds. So you have one more. All right, you want to make it really big. So that I was kind of waiting around. All done. Thank you very much. Yes, I'm here. Oh, she's ours. Are you sure? How did you do it? Food for the Oh, really? It's on that left door when you open it. Right? Right? If you go to our homepage. Now you're trying to know the water. Just click on that's what I tell these guys. It's not letting me use your overexposed water pop up and email address and then we'll ask you for newsletters. Yeah, that's what I tell them. Just set it out. I want I don't know what's going on here. She's at home. Construction project. Which one is that? Change. Now you're later. Oh, the very first one. Yeah, she's living. Oh, the first two. Oh, okay. Because you're the minor. They don't allow people to well, it's up to you. I was going to say you can, and then if you decide to just say you've got those services on you just pass. So you have better to do that. So you have to sign here. You need one for each one of them. One's 10A1, one's 10A2. Yeah, when it comes up, just put one. Yeah. Raymond is, it's 10A2 and 10A1. That's why it's important that we come to state because they know the Franklin School. I don't know if you ever put a situation there on the front. But actually, since you're speaking on two, you can stay speaking on one and two. So I was, yeah. Well, just put three in the first one and then on the second. You don't have to. So, like I said, once they call it, if you're fine with it, then you can just say, yeah. This is pretty good. That's her entrance. See the holes and stuff? This is, you can see with the flash. See, there's no laundry there anymore. You click, you see the laundry. Oh, yeah, she complains about the water, yet it's her work bin in the back that complains of the neighbor. All right. That's the entrance. Okay? It's hard. Yeah. So you got to why don't you just finish this out? Oh, yeah. Stop, Steve. It's 7 o'clock. Right? The lights are on fire. Yeah. But if you here's the water meter. I sent him this picture. You can't have a water meter exposed to the elements because there's a gas flame under there, right? No, so currently there, say you have a water meter where metal, so closure has to be. Because here it's water. What? Thank you. It has to be. Well, it doesn't have to be. It's not working. Right? Remember the police officer said, gentlemen, water heaters are raised off the ground. They're closed, raised off the ground. I was saying that. Yeah, you can see it. I can tell you pictures. It's not zero. Well, but I know you.
Does that automatically mean that the remaining parents have some of the difference, which isn't there?
You can tell me a 65-year-old lady walking. What happened was I always picture her. Right? She used to have a padlock. See, oh, this is 10:47 on a Sunday night. Right? I picture from like 5, 6 in the morning to 10, 11 o'clock at night. 70s, but you know, we everybody's home one week, right? Not really. So she comes back and says, oh, I'm at the gym. Till midnight. I'm showering there. I'm going out to church.
If anybody parks in the parking structure, I can give you validation for your parking.
How about the lot itself?
Or the, you know, I can give you a validation, they're in the process of changing over, so I'm not positive that no one's worked there, but if they don't, you can push the button and let them know that you have validation.
Oh, this is not yet Sunday, Tuesday, Saturday. Now, why isn't she home? She went to church and only she was back. There you go. Oh, yes. Here's Friday, that same weekend, 10:16 p.m. to 25, you know, I don't just.
Yeah, stuck out the way.
So you just came out and stuck it.
Yep.
That's really good.
All of these.
Well, yeah, they make me do it. I have them all, you know. They're like, this is just a couple days ago. At the end. In the dark. Oh,
So mine is gonna kind of keep it there before you. He said if you want to go down the alley.
I wanted to check this.
You didn't get to the steps, you gotta go through those trenches. And you look close, those trenches all blocked. It's in there. Days and
Help
days.
myself use in there.
It's a, see, it's a story. By the way, it's being retrofitted. The whole thing is like, all of the retrofit, there's a problem, so you gotta it's basically revocable. There's no power in the
No.
garage, you know, nothing about that.
But
There's a lot of
I,
these areas just
I'm saying that I used some of the patterns that worked.
But you took it all away.
Demonstrated how across the house.
Right, but our windows and our kitchen does.
Yeah. Sure.
When you hear the sound of
All
the
the same. Yeah.
shower water, she showers.
But, we, you know, I was frustrated because I talked to Dave, you know, the same way down there. And he said, well, last time I was, it all set apart. So the cottage was here, so. Much kind of like that. I think we did have to have one member provided courtesy vote. We wouldn't expect to get it on the floor, so we thought we would get it out of committee. They just had to change the pressure.
Yeah, I don't know.
One of the problems is now that you remember, I can also chow would not have running time. So there's no upside. But if the decision was anyway, because all those government can still not pass on the wall.
Gail says December
Unless we don't get
17th.
too much lawyers, they're not.
What does it say there? Sunday, December 17th.
If it's worth it, or whatever.
See, that's the one.
Yeah, it's just like, why?
I don't even want you to go here. Mine got a day's law. She's trying to do something.
I can't demonstrate that it's not in the situation.
Not even with her.
But they also made a bunch of noise about it.
Oh, that's great.
Nobody saw it.
I can't take a picture of my son.
So I'd like to see some commercial for you.
You think I sent that out?
Well, that's what we were saying, let it out, and then when you want the same decision, vote it down right now, we're screwed.
I had a call today from
And these guys are not. Not there now.
and then somebody
Was that staff driven, or were there advocates?
Danny Boy, you just heard it from the police officer. They gotta be off the ground. They gotta be enclosed. There's gas going through there when they're on, right? There's a gas furnace at the bottom that you can adjust if you want hot or water, more hot, right? So it can't just be sitting up against a fence, tilted, in a demolition zone. It's gotta be encased.
well, if it's, you know,
Why don't you show that to those people over at Health and Safety and Joint? But the most important thing, also check with my insurance provider. They would never insure her to live in a demolition zone. But they prove she's not living there. She needs insurance to run a business. No. I showed rugged dirt, filth,
I can show you pictures
From six, right? I remember the tractor and the holes and that, but now it's worse.
You wouldn't know which was from which side.
Oh, come on. No, it's worse now. There was no trenches by the entrance and all around and the wood everywhere. Oh, a few things, not like, come on. I'm the one who took all those pictures. No. It's new evidence from a new time. Evidence, I don't want to go back a year ago. I'm talking about right now, all we're doing is asking you guys to investigate what's going on now. Like you did years ago when we came to you and said, hey, there's a problem here. Well, I'm coming to you and saying, hey, there's still a problem here, please investigate. That's all right. And we're like, no, we're not going to investigate. She says she's living there. She says she's there at 2 o'clock in the morning. That's good enough. And it's a total mess. Come on. And safety issues. There are safety issues on the property that an insurance company will not insure her. So we don't even know if she's insured now to be running this business. Right? I know that you're going to say technically I'm rent control and insurance to running a rent business is not our department, but she still needs insurance. Stop. And when it's stop with the water heater. It's like I can't even believe you're like I show you water heater tilted against the wall. Oh no, I won't stop till we get it right. My pictures of the total mess I thought were brilliant this week, showing you how close we are. And by the way, the last couple of days, obviously she's having permit and insurance issues because even though it was raining at the beginning of the week, raining in the middle of the week, all it's been is a mess. Hasn't been. She was living there, Dan. She'd like, guys, hurry up. I want this done so I can. 2.5 years later. She doesn't care because she's not living there. If you lived at someplace, when my daddy rebuilt his house and everything else has gone down gutters and stuff. He and my mom moved to Malibu. They'd come in once or twice a month and see what's going on. I mean, they had a big house. They were building a brand new 2-story back house. They didn't want to be anywhere near it, even though the back house was half an acre away from the front house. No, and then back house is done when they're remodeling the front house, but just the back half, not the whole front half. Where they could, but again, they weren't living anywhere near it. They couldn't. Like you said, people don't do that. And I didn't like, no offense, in Hawkins' letter where he says, oh, she's building something next to. No, she's in the middle of the demolition zone. She's supposedly rebuilding that unit. Rebuilding that unit and doing additions and a retrofit. You can't live in a property that's being retrofit, dude.
They haven't said that it's uninhabitable.
They can't insure it.
Code enforcement hasn't said.
What?
Code enforcement has not said it's uninhabitable.
Yeah, well, you know, they haven't come and looked in the last 6 months. He's come to see you. No, he's come, like, when it was warm in the summer, Cordova came and saw the fencing and said she can build, but she has permits to build here and to do demolition work from 10 to 3, and he cited her a couple times for doing work after 3 or not having her permits posted or whatever. But he hasn't been out there to check out the living conditions in many, many months. They've gotten worse. When he was there was a washer dryer that she wasn't using, but it was in that little closet. There was a water heater in this, like he was saying, in that little closet. Now, you can't ever use a water heater that's exposed to elements like that. It can blow up. It's got to be encased like ours. And I'm going to take a picture of you. I'm going to open the door so you can see the water heater inside. Then I'm going to take one of it closed and I'll send it to you tomorrow. So then maybe you guys will understand. You can't use that.
Looks like open and closed.
No. It proves you're not living there in good faith. You got to be able to shower. You got to be able to have hot water. You got to be able to do a washer dryer. You guys are missing. You're stepping over your whole 7 criteria, Dan. That's what we're going to discuss tonight: insurance, safety, and 7 criteria. Well, you keep keep saying I haven't given you guys new evidence, and I've given you like 500-600 pieces.
Well, that has been in of our.
No, yeah, I've given you 500-600 pieces of evidence from this time. Not from a year, because a year ago there wasn't, or nonsense, because a year ago there wasn't a wall on it. Yeah, well, we'll keep going until we get until you guys say, no, Nick, we're gonna reinvestigate.
You're in the right to keep on going.
Right, something is gonna give. Oh, boy. Did they start at 7:30? We're like, Nick is here. Uh-oh. Nick is here. And he's working the main room now. It's Vegas. It's Shecky Green. He's back in Vegas now. I'm not in the lounges anymore at Santa Monica Civic or the library. Go wash my hands real quick. Closed session.
They just put in new equipment, so it's a little different depending on where you park.
You know, the parking structure over the bridge, over the freeway bridge, shopping mall.
No, we don't. Is that where you park?
Yeah.
No, it's not like.
Where do we have to go?
The one here, that's right over here, behind the courthouse.
Last time I've gotten validations of stickers over here. So Shane,
The machine does not work because
you used to.
it did, but they put in new equipment and they're not gonna replace these machines. So that's not gonna do anything.
Well, we'll see. On the parking off the page. Couple dollars. You see my friend Dan here? I'm the biggest persistent jerk he's ever run into in his life. But deep down he likes me because I just get it.
It's a flat rate, I think.
No. We'll be all right. So let me speak pretty quick, because Dan No, he told me he let me go on for about 12 minutes tonight. He was telling me he's stuck. So yeah, he's stuck. We just do the best we can do, people. But I'm glad I came here. I'm glad this is, I know, but I'm glad that I came here tonight. And then now, what do we now? You know, I told you, sooner or later. I think you guys will say, oh, hey, he's always in that. Because what happens when I say you can't get together? Yeah, I think at the end of January, it's going to say how it's built. Again, 2 weeks later, again, I know it's built in. You know, you can blame the weather for a day or two.
Let me tell you something.
Like you said,
It's a special situation.
she really was a lady. So you guys, not a lady.
Every Friday it's claim check.
There's certain things we don't get to the bottom of living. We won't see her insurance. If you guys have insurance, we will rent to people, whether it's renting or not. She has to have special insurance for her demolition zone, right? And that insurance policy will say, because if she's attempting to live there, first of all, you say no. Second of all, well, attempt to live there, but it's going to be coming out of more expensive. We're going to insure you in case something happens to you. The insurance, it's such small amount of forward. I had plenty of insurance in my parents' situation. The insurance, the construction of his home, so I was insured, but I'm sure for them to be living anywhere near construction zone, the price is sky. The odds of something going wrong aren't great. Right? When you look at it, it's like us, we want to see her return. What's not the rest of them happening? Right? Oh yeah, something happened, but to who? To where? To what? Like who's protecting? What? Exactly, but who's protecting them? Yeah, the rent people work for a while. Now they have no protection at all. You know, there's a lot more if you were just saying, I'm living here, here's my rent. That would be fine. And like I said, maybe I can see if you can trust some bill. It's possible that she could be living somewhere. But now she's living in like storage unit. That's in the middle of a demolition, and you know any day you're on the walls and that's all she. Of course, years from now, when she's actually built something. But what we're saying, and we totally agree with your thinking there, we totally agree with it, but we're saying, yes, Dan, that's 2 or 3 years from now. You guys should act like the future's today. The future is not today. What's today right now is a demolition zone. You said that oncoming and oncoming and oncoming demolition zone. Built, there's definitely wasn't living there, blah, 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 blah. Now we're seeing this total demolition zone. You have somebody say, sometimes common sense has to which is all this board was ever supposed to look at, which taught that Stephen said, it isn't that. And now it's even worse, because I showed you where we're on, because when you get pictures of the heat water heater, our water heater, and her water heater, so you're going to say you're right, you can't use it. So suddenly she's down to 2 out of 6. You can't just have a water heater leaning up against the wall. It's like, oh, blow up. Here comes Miss Phillips. So we're probably about to start. Maybe.
Hi, Brian.
How are you?
Good, how are you?
Good. talked to Dan about this. I'm gonna turn pictures of our water heater, which is outside, which is enclosed, which has a flows through water heater system up the water. Resting against the wall, outside of the elements, on. Now it's not working or it's off. Canvas. Beautiful. That's it. I'll definitely look at it. That's it. We keep going. You guys are unbelievable.
You got your own folder on our.
On your computer? Oh, no. Hey, you know what? Well, when you submit 500-600 pieces of new evidence from this topic, you know. Something will happen.
Where'd you go?
Where's your car? Go with the gym. Driving. Unless you like to buy one.
Go to the gym too.
Yeah, is that where it is? Yeah, I don't know where it is.
No, it's in Monday.
And her church. It's a little far to walk, so. Maybe she's ready for a marathon. 65. She's hopping over the, jumping up. She's got bobbing in the trenches. The trenches
Like
are bobbing. She
parkour.
climbs the fence.
It's the French thing, the parkour, you know, they come from.
You've seen it, right?
I like it low.
But like you said, you gotta get to the bottom of this insurance issue.
No way. No, pull it up.
Because you gotta have insurance to run a business like that.
It looks like
You gotta have insurance for her to live in
That's
the
not the
place.
issue.
Well, here, yeah, it's different, but I need to get to the bottom of that insurance issue anyway.
I mean, if you want to do a low, come and see my house.
Because insurance can buy out, so they never insure it.
And you're like, well, I was low.
And you issue manual.
I'm sure it's probably like,
Condo lost 13.
no pod.
When she's jacking up the rent, it's not gonna cover the 3 years worth of demolition.
I know, I'm sorry, I don't know where yours. No, that's okay. Too much. It's fun, right?
Okay. There we go. Check, check. Okay. I know. Where's my gavel? This is the last night I can do it. The meeting of the Rent Control Board is hereby called back to order after its closed session. Please join me in the salute to our flag.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. Very well. If we could have the roll call, please.
Commissioner Trosis,
Here.
Commissioner Foster,
Here.
Commissioner Phyllis,
Here.
and Commissioner Duran.
Here.
And Commissioner Flora is absent tonight.
Okay, very good. Thank you very much. Just a note, if anyone wishes to address the board, either on a specific item for tonight's agenda or in public comment, please see the secretary to fill in a speaker's slip if you've not already done so. All right, if I may, can I have the report of closed session?
Yes, the board met in closed session at 6:20 to discuss contract negotiations with 3 of the agency's collective bargaining organizations. We concluded, as you saw, at about 7:25, and there's no reportable action.
Okay, thank you very much. Now, moving on to approval of the minutes. The chair will entertain a motion. Okay. It's been a motion, first and a second, to approve the minutes from the December 7, 2017 meeting. I'll take a roll call vote. Oh, voice vote. Okay, all in favor?
Aye.
Any opposed? Any abstentions? Okay, the ayes have it. Now, moving on to special agenda items. Go ahead if you have any.
Yes, I have a couple of things I wanted to mention tonight. Next Thursday, January 18th, the City Attorney's Office is offering a fair housing symposium. This event will commemorate the 50th anniversary of the passage of the Civil Rights Act in 1968. They're inviting the public to this unique symposium where they have some very interesting speakers, including one of the congressmen who voted on the Civil Rights Act. It's going to be from 1:30 to 4:30 at the Martin Luther King Jr. Auditorium at the library. And anybody who's interested in attending should contact the City Attorney's Office and sign up through their website or give them a call at 310-458-8891. And the next seminar that the Rent Control Agency will be hosting will be the Owning Rental Property in Santa Monica that we offer each year. It's tentatively scheduled for April 3rd, and I'll provide more information about that as it gets closer.
Are both of those on our website?
Yes, we have announcements about both of them on our website.
Great.
Okay, thank you very much. Moving on to public comment. This is the time set aside for members of the public to address the board on matters that are not included on the agenda, but that are within the board's jurisdiction, subject matter jurisdiction. Please note that we cannot take any official action at tonight's meeting on any matter not already included on the agenda. And now I have some requests to speak. The first I have, Lori Brown. Oh, it's okay. Sorry. Well, this is 7. No? Public comment is... Okay, then let me see. I don't have a chit for you for 12A, so you may want to... Okay. Or I can do it for you. I'll do that. I'm here to help. 12A, okay. The next speaker I have is Nicholas Gross. You've requested 3 minutes. Mr. Gross?
Working? Hello?
There you go.
Hello? Hello?
No, the red one.
Okay. Now we're working? Okay. Good evening, board. Happy New Year. I'm going to try and be pretty quick tonight. The few topics I want to cover real quick are insurance, and again, the 7 criteria that need to be fulfilled in order for a landlord to get a rent control exemption. You know, on our property, no insurance company would ever insure Ms. Chen to live in a demolition zone, especially during a retrofit. Yet Ms. Chen is saying that she is and demanding $4,200 to live for us to live right next to the demolition zone, as if her product was complete 2 or 3 years in the future. It's been 2.5 years. All it is a demolition zone. I've turned in 500-600 new pieces of evidence. Really quickly, the 7 criteria. Many months ago, they said last year, the board, the staff attorneys, the judge said she fulfilled 4 out of 7. We're wondering why that's the law when they have to fulfill 7 out of 7, yet the board itself never reviewed the 7 criteria at the hearing. That's what's on the book. She has to fulfill all 7. Your staff, your judge said 4 out of 7. Now, she's got no laundry. She's got no water heater. She's got no gas. She's at 2 out of 7 at most, right? She's been on the property maybe 2 or 3 days in the last several months. As they know, we live 8 to 10 feet from there. We had turned in 500-600 pictures of a locked construction zone from 6 in the morning to 10, 11 o'clock at night, and all day on the weekend. She's never there. And her lawyer shot back saying, well, she comes in at 2 o'clock in the morning and leaves at 5 a.m. We're like, oh, that's great. So you're admitting that she's not living there in good faith, right? But there are safety issues. Power lines have fallen. There's hot water heaters there. I don't think it's connected. Matter of fact, I'm sure of it because it's leaning up against a wall. Our hot water heater, and they want us to send a picture of it, is actually enclosed in metal casing and it's level. It has to be this way because there's gas there, right? The whole thing could blow up. So she doesn't have hot water. She doesn't have gas. She doesn't have her washer and dryer. Everything's all been, and there's trenches all over the place and filth and mud and wires and wood, and the whole entrance is completely blocked, even up her rickety stairs. This, like I said, this has been going on for 2.5 years. You know, again, we're not 2 or 3 years in the future, right? The storage unit she has is supposedly going to be reconstructed, yet the whole area is a demolition zone, right? There's no way she could ever live there. First of all, being renters and stuff, we want, and the board used to protect us, but we want to see the insurance. She's got to have insurance to be able to rent these units. And her premium would be so high for her to claim to an insurance company that she's actually living in a demolition zone. Her insurance would never allow it. So her whole concept is preposterous, right? Now, the guys were kind enough and said, hey, Nick, you've submitted a lot of pictures, and we're not worried about last year. We're talking about this year now. So the bottom line is she's not been living in good faith in the property. And we know these things because we're merely feet from where she supposedly claimed that she's living.
Thank you, Mr. Gross. Your time is up.
Last thing, there's been changes in the last year.
Thank you, Mr. Gross. I got to stick with the time.
Yeah, okay. We'll see you next month. Thank you very much. I think we've covered what we could. We're just asking you to please investigate now this year.
Thank you, Mr.
All right,
Gross.
thank you.
Next, we have Mr. Wellman, and you have requested. Oh, I am sorry. There was one question by from Commissioner Phyllis for Mr. Gross. Excuse me.
Yes.
Two things actually. First, Lonnie, I think our name queue is screwed up. It says I'm Todd. Mr. Gross, you did file an inquiry or request that the board or our staff investigate the owner occupancy exemption,
Right.
correct? And that's still under investigation?
Yeah, they want me to submit more pictures. Bottom line is there's safety issues. It's extremely dangerous. No one can, you can't claim to be living in a demolition zone with huge trenches and wires and wood. And, you know, I've showed them what a total mess it is. And the bottom line is things have changed from a year ago, but they haven't changed in the last few months. It just keeps getting worse. Well, it's changed for the worse. It just keeps getting worse and worse and worse, and nothing's been built. If somebody was living there and wanted to live there, certainly in the last 2.5 years, they've been able to add on a couple rooms. But she doesn't live there. She doesn't care
Okay.
how long it takes.
So I trust that staff has taken note of this and is working with Mr. Gross.
Yes,
to
they are. They've
complete
been
the
very. I
investigation.
want to say something about Dan and Haka and Stephen. They've been very patient, very kind, very interested. They're just waiting for that one piece of evidence that breaks things wide open. I'm going to take pictures of our water heaters to show them that ours is actually safe. Hers, you know, if she doesn't have water, hot water, and she doesn't have laundry and all these things, and not eating their meals there, she's nowhere near the 7 criteria, which is what the board is supposed to rule on, not metadata that can be altered. These guys did their report. They told you she didn't meet the 7 criteria. The judge told you she didn't meet the 7 criteria. All you guys are supposed to say is, sorry, ma'am, you don't meet the 7
Thank you,
criteria.
Mr. Gross.
You
See
guys
you
know
next
the
month.
laws better than me. All right, thank you. Thank you for listening, everybody, and thank you for the extra time.
All right,
Thank you.
Happy New Year.
I just wanted to
There's
say,
one more
are
question.
there health and safety issues at your unit?
Yes.
Okay, so I would trust that staff has informed you as to what your remedies might be in that situation. And I just wanted to express, I understand that this is an extremely difficult situation for you, and we appreciate you coming here and continuing to
She
keep
blames
us apprised.
the next door neighbor for the water usage when he waters at 11 o'clock at night to save her water, and then you go out in the alley and it's totally flooded by her workmen. I took pictures and showed them. It's like,
yeah.
come on, she's harassing us.
And obviously we love our staff, they're amazing, and of course trust that you're giving them all the information and they're doing what they need to do.
I want to say something. I've given them a real earful. They've been very patient, very kind, but I've also come up with a lot of great new evidence about this year and these past few months. We can't go a year ago. Except things have gotten a lot worse.
Okay, we appreciate your
Thank you for listening,
your expression.
everyone.
Thank you.
Thank you. Now, if we may have Mr. Wes Wellman. You've requested 3 minutes.
I'm Wes Wellman. Good evening, Commissioners. I hadn't planned to talk tonight, but before I came, I got an email that I thought I would read to you from an owner. She has 2 buildings. She hired a structural engineer to begin complying with the earthquake retrofit law, and she sent me this email tonight. My engineer told me that he is not interested in doing engineering for my other building. He said no one responds to his phone calls on our projects, nor to his emails. He said he has lots of projects in the city of LA, and plan checkers are much nicer and easier to work with than in Santa Monica. This is very bad news for such a small town. I had occasion to talk a few weeks ago with another contractor that does a lot of work in Santa Monica. And he says he has great difficulty hiring subcontractors. That when he calls someone and says, I have a job for you, the first question they ask is, where is it? And when he says Santa Monica, most say, forget it. And he said, if I do hire someone, I have to pay about 1/3 over market value to get them to take the job in Santa Monica because of the extra hassle. I'm familiar with another contractor, retrofit contractor, that I've worked with in the past that's actually quite reasonable. And I haven't talked to him directly about this, but another owner told me that he's doing no retrofits in Santa Monica. So I'm just here to say, Houston, we have a building to safety problem. Certainly it's not something that owners can have any influence over, but I know you're concerned with there being timely and widespread compliance with the retrofit law. So to the extent that you can have influence on changing the culture in building and safety, there's an issue there. Thank you.
Thank you, Mr. Wellman. It looks like Commissioner Trosas has a question for you.
Hi, thanks for coming and thanks for sharing that with us. I think it's something that is unfortunate to hear and something that all of us have hopefully heard before this concern echoed. We sent a resolution to City Council last meeting regarding the safe and affordable financial products, which I know is separate and apart from what you're raising here. I would like to hear from Building and Safety, and I think I've asked to hear from Building and Safety a number of times now. They came to our meeting one time. I was hoping that that was the start of an ongoing conversation with them about how we can facilitate this process for both landlords and tenants, so that there's a little bit of a smoother interagency dynamic here for the sake of efficiency. I would like to hear from them as to exactly what they're doing for the retrofitting process to help landlords and tenants. Thanks.
Thank you, Mr. Woman. Oh, one more question? Okay, I'm sorry. Excuse me. Commissioner Foster has a
Ms. Condon and I attended a city meeting, a public meeting that had engineers and members of the Planning Commission and Building and Safety and Code Enforcement. We're all on a very long panel, 2 or 3 hour meeting, and they assured members of the public that there would be staff added and a special hotline and a special delegation, if you will, of employees dedicated to precipitously moving through applications. The word fast tracking wasn't exactly what they used, but they said expedited. They did use those phrases. And so I think all of us are within our rights as it affects tenants and landlords to inquire as to what the progress is or what the volume of calls and replies and the time frames look like.
I attended the same meeting.
Thank you.
But I just thought I would share this with you and give you a heads
That's
up.
fine. That's we intend to look into it.
Thank you.
Thank you. I now have Elaine Golden-Gieler, and I understand that she has a video, so that'll take just a couple of minutes to set up. In the meantime, I'd like to make a comment that the stamp machine out there for validation isn't working, I understand, but our secretary has validation parking slips, so go up and see him if you need one.
Rather than just catch it later. I just want to make sure that City TV is actually watching and will start the video when it actually starts. Whoever and wherever you are, City TV, please pay attention.
Almost like a pollution, huh? Yeah, but it looks like it's.
Maybe you need to plug this in.
No, it has to run through the browser.
Okay. There it is.
It's on the screen, it's not there.
I want to say something before it starts. Where's the button where I touch it?
I don't think it's gonna work. I'm not able to get it to work.
Did I mention that if you haven't already received your parking pass, you can see our secretary? He has them available.
Can you put it back on there again?
All right.
Yeah, I don't think that's gonna work. I'm gonna try something else.
Okay. We checked it out in advance and it worked.
Yeah, for some reason it's working over here, but it's not showing up on the screen. City TV to the rescue.
Dun, dun, dun. Where's your cape?
They're here to help.
Yeah.
I thought you guys were somewhere far away. I don't want it to start until I say a little introduction. Okay. So, to encourage passage of bond measures, our city leaders made promises to property owners on how pass-throughs would be handled. Regarding the obligation of honoring agreements, I offer the following expert witness.
And I'd just like to add one thing. Just being very human here. The way that I would want you to think about this would be to say, welcome to Eldon, pick out a house, commit to moving into it, then we'll tell you how much it costs later, after you've closed. So a developer who chooses to start a business or a construction project in a certain city is told something in a handshake and some paperwork is begun by the city's administration at that time, then that's your understanding. You would not proceed with a project in a given parcel in a given city if you don't know the setup, if you don't know the framework that it's in. So nobody would come to build or start a business if it's optional down the line. So what I'm saying is, us or a future company that might want to start a business, if an administration has told you it's one set of circumstances over multiple, this is our understanding, over multiple conversations, multiple meetings with our bank lenders in person, and that this was the handshake, absolute understood arrangement, that's what we counted on. So that's what all of our entire framework for this project is based on, is 10 years at no property tax additional than what we're already paying, and then 10 years at the 50%, and then full, at that point. That's when it was the original EEZ arrangement. Then when, a clerical error, found that that's not the proper mechanism, we just don't feel that it should undo and just reopen the entire thing to a random discussion of what we feel like giving later. It's that a project is formulated and we calculate what we as a family can do. We might have chosen another city, another time, another place if we thought that this deal could just be upended and completely changed. So that's just the very human situation we find ourselves in. So we just don't want to come to town, choose a house, and then later be told how much it costs. It's hard. It's a hard way to plan your business.
Well, as they.
Thank you.
Okay, thank you very much. That ends our public comment section. Moving on now to jurisdictional items. 10A, appeals. This is case number D4988 at 436 Richmond Avenue, unit number 4, by appellant J. Stores. May we have a report, please?
Commissioners, Mr. Stores filed a rent decrease petition alleging various maintenance conditions and reductions of housing services. And the hearing officer for this case asked the hearings investigator, Mr. Pete Savino, to visit the property and photograph the conditions raised by Mr. Stores. In an email exchange to schedule the visit, Mr. Stores demanded that Mr. Savino agree to climb onto the roof and crawl underneath the building to document termite infestation. Because Mr. Savino is not authorized to do those things and is not a licensed termite inspector, Mr. Savino informed Mr. Stores that he would inspect and photograph only those conditions that were observable in his unit and accessible parts of the common areas. Mr. Savino and another hearings investigator arrived at the property at the time discussed in the email exchange, but Mr. Stores refused to allow them into the unit, denied he had agreed to the time, and he threatened to call the police. Unable to enter the unit, Mr. Savino took photos of the conditions that Mr. Stores' petition had raised with respect to the common areas that were exterior to the unit. Mr. Stores videotaped his interaction with Mr. Savino and uploaded it to YouTube. Mr. Savino prepared a report based on what he had observed and photographed, and that report was submitted at the hearing. Mr. Stores objected to the admission of Mr. Savino's report on the grounds that it was inadmissible because Mr. Savino had said he was not going to do an investigation when Mr. Stores had threatened to call the police. The hearing officer overruled Mr. Stores' objection. He asserted that disqualified her from hearing the case and asked the hearing officer to disqualify herself. She declined his request, and Mr. Stores refused to proceed with the case. She repeatedly asked him to put on his case and provide evidence, but he refused unless she disqualified herself, so she ended the hearing. Because Mr. Stores refused to provide any evidence that substantiated his claims in his petition, the hearing officer denied any rent decrease. Mr. Stores has appealed that decision. He has provided new evidence with his appeal, but because he could have provided that evidence to the hearing officer and did not, the board should not consider the new evidence on appeal. It is Mr. Stores' burden as the petitioner to provide evidence that proves the allegations in his petition by a preponderance of the evidence, and he provided none. In his appeal, he attacks the investigator's reports as flawed. He could have done so at the hearing by cross-examining the investigator about the purported inadequacies of the report, but he declined to do so. But even if the investigator's report fails to document the breadth of the allegations contained in Mr. Stores' petition, which may not be surprising since Mr. Stores refused to provide them any guidance during their site visit and threatened to call the police on them, the record lacks any evidence that would support a rent decrease. Staff therefore recommends that the board affirm the decision.
Thank you very much. We have one request to speak. I believe the name is Grant Yui? Ivy, excuse me. You've requested 3 minutes whenever you're ready.
Thank you. This is my first time.
Go to there you go.
Here's the microphone. Okay, thank you very much.
Perfect.
First time here. I'll make it short. We agree. I represent the owner, and we do agree. Thank you.
Okay, thank you very much. There's no other request to speak on this matter. Opening it up to discussion, Commissioner Phyllis.
Thank you, Commissioner Duran. I think this is fairly open and shut. I'm ready to move to adopt staff's recommendations, findings of fact, and conclusions of law, and affirm the denial of the rent decrease.
Okay, thank you. There's been a first. Is there a second? You second?
Yeah.
Okay. There's been a first and a second. Do you also have your name in the queue? Is there anything? No?
No.
Okay. Been a first and a second. We'll take a roll call vote.
Commissioner Phyllis?
Yes.
Commissioner Foster?
Yes.
Commissioner Trosis?
Yes.
Commissioner Duran?
Yes.
Motion carries.
Okay, moving on to item number 12A. Excuse me, 12A2. Case number D4990 at 841 Pacific Street, Unit 841C. Appellant A. Lazar. May I please have a staff report?
Commissioners, Mr. Alexander Lazar moved into his current apartment, Unit C, in March 2017 after first living in another apartment in this property for a couple months. The lease for his tenancy includes a blank line for the parties to state whether storage is included as an amenity. In this case, the line stated NA, or not applicable. The lease also states that it constitutes the entire agreement between the parties and supersedes any oral or written representation or agreement that is contrary to the lease. While Mr. Lazar was in the other unit, he asked the tenants who were moving out of his current unit if he could use the storage area that they were using. They had no problem with it, so he stored some of his belongings in it and he padlocked the door. He also placed belongings in 2 other storage spaces. Mr. Lazar says that he did so after a conversation with Mr. Ivy, the manager, and Mr. Ivy denies the conversation. Several months later, Mr. Ivy states that he noticed the locks on the storage areas. Because he states that he never authorized their use, he posted a notice that the storage spaces need to be emptied and the locks removed. Mr. Lazar did so, but he then filed this petition, alleging that storage was an amenity of his tenancy which had been taken away, and so his rent should be decreased. The hearing officer found that Mr. Lazar had failed to meet his burden of proving by a preponderance of the evidence that storage was an amenity of his tenancy. Mr. Lazar has appealed that decision. The board has the authority to grant a rent decrease to avoid what's called a backdoor rent increase, which is when the landlord charges the same rent but provides fewer housing services. An amenity is a housing service of a tenancy if it's an amenity at the outset of the tenancy, part of the basket of goods that the parties agree the rent pays for. Mr. Lazar states that the lease language that says the storage is inapplicable as an amenity fails to mean that storage is not provided. He points to language in an attachment to the lease that's titled Obligations of a Resident that states that no personal belongings may be placed in halls, stairways, and other common areas except in enclosed storage areas where allowed. But this contingent language does not show that the owner provided Mr. Lazar with storage. Nor does this language conflict with the lease's explicit characterization of storage as an inapplicable amenity. Mr. Lazar also asserts that notwithstanding the language in his lease, Mr. Ivy told him he could use the storage spaces before he moved into Unit C. But the lease already stated that it was the entire agreement and superseded any oral representation made to the tenant. And Mr. Ivy denied, he appeared at the hearing and under testimony testified that he denied ever having told Mr. Lazar that he could use any storage space or that storage was a housing service of his tenancy. Mr. Lazar also argues that since the landlord had not put any locks on the storage spaces, that meant that they were available to be used on a first-come, first-served basis. It's unclear why Mr. Lazar's presumption that he was free to use the storage rooms because they were unlocked is relevant if, as he contends, Mr. Ivy had given him permission. But his presumption is not relevant in any case. Storage rooms are an amenity of a tenancy only if the owner had agreed to their use at the inception of the tenancy, not because they were unlocked. It is also not relevant that the previous tenants had okayed his use of one of the storage spaces. They are not agents of the landlord. Mr. Lazar argues that because he had put locks on the storage spaces, Mr. Ivy should have noticed the locks. But this is not evidence that Mr. Ivy did notice the locks, nor is it evidence of Mr. Ivy's agreement that storage was an amenity of his tenancy when they were signing the lease, particularly since the lease states that storage is an inapplicable amenity. Mr. Lazar failed to provide evidence that corroborated his allegation that Mr. Ivy had agreed to his use of the storage space as a housing service of his tenancy. In fact, the record contains contrary evidence in the language of the lease and in Mr. Ivy's denial. Given that record, the hearing officer reasonably concluded that Mr. Lazar had failed to prove that storage was a housing service of his tenancy by a preponderance of the evidence in the record. Because the board reviews this matter as an appellate body, and it may overturn the hearing officer's decision only if the facts in the record show the findings to have been clearly in error, the record, and in this case, the record does not show that. Staff therefore recommends that the board affirm the decision.
Thank you very much. We have two requests to speak, but I have a question for the staff report. Commissioner Torosis.
Yeah, can I just ask you a quick question? And I think you probably would have stated this if it was true, but is there any evidence that an agent of the landlord agreed at any time to let Mr. Lazar use the storage space?
None is indicated in the
Was
decision.
any introduced? Was it, yeah. And did anyone ask the landlord who the locked storage spaces are for if they're not designated in each individual lease agreement, or are they designated in each individual lease agreement?
My understanding, according to the testimony and the record, is that the storage spaces weren't locked, except for the one that apparently Mr. Lazar testified was locked by the previous tenant in his unit, that's the only evidence that we have that any of them were locked.
I guess the question was, if they're not first come, first served, then who are they indicated to be for? Like, are they lease by lease? Do we know? Was that part of the record?
That was not part of the record.
That was not asked. Okay, thanks.
Okay, thank you very much. I have a request to speak by the tenant, Mr. Alexander Lazar.
Mr. Chair, I just
Yes.
want to know, normally the appellant goes first, but he's requested to go last.
Oh. Okay. Well, then that's
Do we have to agree to that?
I believe that's his choice, right? Or
No. Okay.
he can do it, right?
Yeah.
I can decide. Wow. On my final evening as the chair. That's fine. That sounds fine to me. So then I have Grant Ivy, who has requested 2 minutes.
I'd like to defer to.
I'm sorry?
I'd like to defer to
You're yielding your time. Okay. Thank you very much. Did you get that for the record, or should he come say that into the?
I got it, yep.
You got it?
Yep.
Very well. Okay.
Oh, okay.
Then, Mr. Lazar, you have 5 minutes as you are the appellant. Whenever you're ready.
Before I talk, I can answer your question that during the record, Mr. Ivy said that the cabinets are intended for the maintenance people of the property owner. They haven't been used as such before I moved in, but they claim that will be their future use.
Okay, I'll ask the question
Yeah.
Yeah, go ahead. Yeah.
Yeah, it's also, is it? Oh.
It's on.
So this case boils down to how the not applicable on the storage line of my lease is interpreted. There are several cases nearly identical to mine, except that their lease had no field for storage. In these cases, the hearing examiner ruled that having access to the storage at the inception of tenancy made it an amenity. As Mr. Mordezai said, the basket of goods that is negotiated for. In some cases, the tenant's lease actually has even explicitly said none for storage or another amenity, and the hearing examiner ruled that due to rent control regulation 1807, the lease did not matter except as a piece of evidence. In those cases, the other evidence provided proved that the tenant had access to the item from inception of tenancy, making it an amenity. I believe that the not applicable line on my lease was never intended to limit my storage, and my landlord is trying to renege on the permission he gave me. It is not disputed that I had access to the storage amenity, in my belief, with permission from the inception of my tenancy, and that thus it is an amenity. As I wrote in my appeal, I believe that the severe ambiguities in my lease show that the NA line is not conclusive. If the PETS line said not allowed, why does the storage line say the weaker not applicable? If the not applicable on storage precludes my separate agreement for storage, why does the not applicable line for parking not preclude my separate agreement for parking? To me, this is the big question. Why can my landlord use the term not applicable in one way when it benefits him, and then use it in the opposite way when, again, that opposite inference of the term benefits him? My lease should say, if my lease had said not allowed, I would have had them change it. If my lease had specified parking and consolidated my garage lease, I would have had them explicitly state the storage. When I signed the lease, I wasn't going to nitpick what seemed like a straightforward change from Unit B to Unit C. Grant had given me permission to use the cabinets, and nothing in the lease seemed like it was changing that. California has rulings regarding ambiguous lease terms, saying that they must be interpreted in favor of the tenant. This has been applied by a hearing examiner in the past, which is where I'm quoting from now. The hearing examiner writes, in interpreting contract language, ambiguities caused by the drafter are generally construed to be against that party and in favor of the opposing party, from Neal versus State Farm Insurance Company. In the real property context, again, still the hearing examiner writing, in the real property context, the language of a lease is interpreted most strongly against the lesser. Doubts and ambiguities shall be resolved against the lesser, particularly if he caused the uncertainties to exist, which comes from Cooper versus Mart Associates. The drafter and lesser of my lease is my landlord. They caused the ambiguity by giving me permission to use the storage combined with the earlier mentioned not applicable confusion, versus when they could have used the stronger term that they had used elsewhere. The hearing examiner continues, writing, moreover, California Civil Code 1636 provides that a contract must be so interpreted as to give the effect to the mutual intention of the parties as it existed at the time of contracting. If any ambiguity or uncertainty exists, the lease must be interpreted in the sense in which the leasee believed that at the time of the making that the lesser understood it, from Papadatos versus Market Street Building Corporation. I understood that the lease is not being restrictive on my storage. My belief of Grant's understanding was that he had given me permission prior, and that, as shown, the not applicable did not run contrary to that. During the hearing, Grant tried to speak negatively of my character and used that as proof that I wouldn't have asked permission before using the cabinets. In fact, in another case, there was a similar situation where I noticed an empty parking space at my building. I did email Grant and ask for permission. In this case, I emailed instead of talking to him in person because it was after his phone hours, so I couldn't call in. But for the permission for the cabinets, I had talked in person. There are also two quotes from previous appeals on similar issues. D4718 was a case of removing the use of a patio from a tenant who had permission from a previous landlord. The current landlord had tenants sign a new lease when he purchased the property, as many tenants did not have written leases. When he did construction that negatively impacted the patio, he claimed that because the patio isn't in the new lease, the tenant should not be able to get a decrease related to it. The hearing examiner's decision gave the tenant a rent decrease after determining that the tenant had access to the patio from the start of tenancy and it is thus an amenity. It says the lease is not restrictive, stating that 1807 makes it void. The following quote is from staff at that appeal. The law is clear for tenancies established after Costa-Hawkins that housing services are benefits connected with the unit provided on the initial date of tenancy. If the benefit is reduced or eliminated, then the rent must also be decreased. The evidence here is uncontroverted that the tenant had access to the amenity from the outset of the tenancy. It is also undisputed that the new landlord has taken away that amenity. The tenant is entitled to a rent decrease under the law so the rent does not become excessive. The landlord argues that the tenant is not entitled to that decrease because the lease does not make any mention of the amenity, but that fact is not relevant. Under the law, the tenant had a right to the amenity from the outset of their tenancy, and now that it has been taken away, the tenant has the right to have their rent reduced. Chairperson Flora clarifies that simply an omission of the amenity on the lease does not indicate that the tenant does not have a right to it, which staff affirms. Commissioner Winslow says that granting the landlord's appeal would allow non-stop end runs of the rent control law. Landlords could walk up to their tenants and say, I have a new deal for you. You have to leave unless you sign it. And that new deal is a rewrite that leaves out amenities. The board unanimously upheld the hearing examiner's decision denying the landlord's appeal. D4891 was a case.
Okay, hang on one second. Go ahead and finish your statement.
Okay. Yeah, pretty much my big question is why can my landlord use the term NA when it benefits him and then use it in the opposite way when it benefits him to flip it?
Okay, thank you very much. I have a question from Commissioner Trosas for you.
Right. I have a question for council. So obviously we know general contract law, parole evidence rule, everything has to be incorporated, and that's like a basic principle of contracting. The case law that was cited here, I don't know if it's distinguishable based on the fact that it might have been a different fact pattern than what we have here, but how do courts typically interpret ambiguities for the purposes of leases?
A couple things. The board is not here called upon to interpret the lease. The board is not a court and is not applying contract law. The question is, as a factual matter, did or did not the owner provide the 3 storage units as a part of the tenant's rent? And that's just a factual question. The lease says it's not applicable. I mean, it's included. The lease is not silent on the point. The lease says it's not applicable. That was one piece of evidence that was looked at. It was not the only piece of evidence. There was also the testimony of the parties, and the hearing examiner made a credibility determination based upon the testimony of the parties. I would also clarify that the board's previous decisions are not, as a matter of law, are not precedential. There's state law on that point. The board does, however, and should apply the law consistently from case to case. But there's no evidence as to what the facts were in those cases, or what, the question in each case is a factual one. Was it or was it not provided? The legal framework in this case is no different than in those cases, which is if it was provided, then it's a housing service. So it's really purely a question of fact.
Okay, but I understand that it's a question of fact, but I'm having a little bit of trouble determining what the facts are. So I have a question for you, but I kind of also have a question for Mr. Ivy, who didn't say anything. So I'm looking at the lease here. We have NA for storage space. We have NA for late rent charge, NA for parking space, and NA per added occupant rent. Mr. Ivy, is there a late rent charge in this building? No. So you can be 60 days late on rent, no problem?
I'd get evicted.
Yeah, right. Okay. Did he get a parking space? Yeah, you need to be on record. Can you come up to the front? Where does it say that he has a parking space in here?
It's a separate agreement for the parking space.
So why would it be written NA in the lease? Not like refer to separate agreement, refer to addendum, refer to amendment.
That's what I was instructed to by the office, because there was a separate agreement, so it didn't. The parking was covered by a separate agreement, and then.
Just to clarify, that is in the record. The actual agreement is in the record.
Yeah, no. And then, did he have extra occupants in the unit? Did you charge him any rent? Was there any additional occupant rent for additional occupants in the unit?
Negative.
Okay. Was there any mention of making any sort of changes to this lease agreement when it was signed? Were there any hesitation to signing the lease?
None.
Okay. Those are all my questions for Mr. Ivy.
Do you have questions for Mr.
Yeah, no,
Gonzalez?
I just, I'm looking through my notes to make sure I don't have any.
I don't mean to rush. Just curious.
Why didn't you write anything on the lease if you disagreed with it when it said NA?
Because they didn't, like, I actually asked about, like, does the NA mean anything because of my separate parking things. I didn't want to lose the separate garage. And he said, it's fine, it stands.
Like, it's fine, you can use the storage unit, it's fine?
I don't remember if he said exactly it's fine, but I know that I would not have signed that lease if I wasn't going to keep my garage, and I wasn't going to sign that lease if I didn't keep the cabinets.
What does not applicable mean to you?
Well, he said that the separate, like, because I had the separate piece of paper for the garage, that the agreement stood.
And so why didn't you think about asking for a separate agreement for the storage space?
Because we already had an agreement. I had already asked, like, can I use the cabinets? He said yes, and I did.
A verbal agreement?
Yeah.
Okay.
I'd also like to point out, I was looking for my final statement because I was in the middle of my writing. The
well, hang
yeah,
on one
I
second.
mean,
your time is up. If you have it as part of a response
I'm
to a
just
question,
you
can use it then.
Did you see maintenance workers using the storage lockers?
I've actually explicitly asked the maintenance workers if they would ever want to use them after the issue came up, and they said that they would have no need of them.
Okay, those are all of my questions. I think Commissioner Phyllis has some.
Also, on the maintenance people thing, the property owner and the property manager have had two different answers on that regard. Just the answer that they have in the record.
Yeah, what I mean, I can only consider what's in the record. Okay, thanks.
Thank you, Commissioner Phyllis. You had questions for Mr. Lazar?
Yeah.
Okay.
So, Mr. Lazar, first, do you have a final statement that you want to conclude with?
No, I just wanted to point out that Grant said that this is his first time up here when it's not. It's at least his second from what I know. And that just shows
Mr. Ivy, you mean?
Sorry, what did I say?
Grant.
Sorry, yeah, Grant
okay.
is, he's been up here before, and I think that just goes to show that he doesn't always remember when previous stuff has happened. I fully believe that whatever happened when I asked him about it, like, on the record during the hearing, he recalled me asking about putting in bike racks in the courtyard, and that was the same conversation where I asked about using the cabinets. I fully believe that he gave me permission and then just didn't remember doing it, and when the cabinets came up again later and the landlord said, oh wait, we're not supposed to give those out, he just took them back.
Okay. Thank you. I have a question for staff, actually, really quickly. Could you please remind us of the standard of review? I understand this is clearly erroneous, but I think a little further explication on what that means would be helpful.
Yes. It has to be the case that no reasonable hearing examiner could have made a decision that was in fact made based upon the evidence that was presented in the record. So if reasonable people could look at the same record and reach different conclusions, that is not a basis for overturning the decision.
Okay. So, just so Mr. Lazar understands that, I mean, that's a very, very high burden. We're not looking at this as a clean slate. And I don't know. I'm struggling, as I think some of maybe my other commissioners are as well, because I think what we have is a written agreement that doesn't appear to codify every agreement that the tenant had. The tenant's course of conduct indicates that the tenant repeatedly used these storage units, and it seems to be a fairly integral part of your lease. But the really bad fact for you, and the fact that I really can't get past, is like you have a lease that says NA, and you don't have, unlike the parking agreement, you don't have a parallel agreement or a side agreement or anything to codify this agreement with the storage unit. It puts us in a really bad position. I think if we were sitting as a board of original jurisdiction, it may be a different situation.
I would like to point out that I've read every decision regarding storage since 2012, and none of them, given a verbal agreement for storage where the tenant was using it from the inception of tenancy and landlord later came back and took it away, none of them went in the landlord's favor. And that includes a couple of cases where their lease said none. I mean, most of them were blank for storage, but several of them, well, two of them said none.
Okay, so I guess I really do appreciate that you've gone back over these cases. Obviously, they're not precedent, but I think we can look at them as persuasive evidence of how we want to interpret the law consistently. So if you had one shot to convince this entire panel, what is your best case for saying there is literally no reasonable basis on which one could say a storage unit is part of my, or not part of my lease? What is your best argument?
The fact that I have an NA under parking when I clearly have parking. That basically, if they wanted my lease to not include storage, then they would have said, okay, here's your parking line that says here's your parking, and oh yeah, we're not giving you storage because it says none.
But you have a separate agreement for parking.
But I have a separate agreement for parking, and I thought I had a separate agreement for storage.
But parking was written.
Yes.
Okay.
Because parking, I had to go and negotiate separately, just like I did with the cabinets.
Yeah.
And when I switched units, I thought I was getting the cabinets with it because I had the cabinets when we negotiated the lease.
Yeah.
Okay. Any other questions for Mr. Lazar? Commissioner Phyllis?
No.
Okay, thank you very much. You can have a seat. There's no other requests to speak, so I have Commissioner Torosis to start the discussion.
Yeah, I just want to thank both parties for coming here tonight, and I understand, it's a difficult situation on both sides. I have to say that, again, we're like, to echo what Commissioner Phyllis said, we have to look at this from a clearly erroneous standard. And I think if you look at the law and even a basic layperson's understanding of the law and of contract law, and I know our counsel here is going to say that's not relevant, but if you're looking just solely based off of how our hearing examiner made a decision here, it does say NA on that line. The thought is that everything is going to be fully incorporated at the time of lease signing. I do understand that you have this argument that there's a separate agreement for parking. I think that we can't expect everyone to be so aware to know that a verbal agreement wouldn't be considered in this situation. So I understand what you're saying, that you thought that you had two separate agreements for these two separate issues, but I don't see one here, and I don't think it's unreasonable the way that the hearing examiner decided. Certainly, I still have several questions, but I don't think it's unreasonable what was decided here. So I mean, for me, I have to affirm the hearing officer's decision.
Thank you. And I'm in the queue next. I'd like to say also that I agree that the hard part that you have, Mr. Lazar, is that it is not unreasonable to assume that the hearing examiner made an unreasonable decision, if that makes sense. I mean, not applicable in terms of just common definition use for of the phrase would mean that it doesn't apply, and so it's reasonable to assume that in my mind that the hearing commissioner, the interpretation by the hearing commissioner was a reasonable one, and without more, I feel like I'm forced to affirm the decision as well. So having said that, the chair will entertain a motion, or will make one himself. Okay, I move to that we accept the hearing officer, affirm the hearing officer's decision. And as the chair, I never do this. So, and accept the conclusions of law and findings of fact. Do I have a second? Thank you. First and a second. Can I have a roll call vote, please?
Commissioner Phyllis.
Yes.
Commissioner Trosis.
Yes.
Commissioner Foster.
Yes.
And Commissioner Drawn.
Yes.
Motion carries.
Thank you very much. Moving on to jurisdictional item 10A number 3. It's case number M0954 at 2535 6th Street, Unit 2537. The appellant is J. Cernick. May we have a staff report, please?
Commissioners, this is an excess rent claim that was filed by Nicole Ariola, the tenant in Unit 2537. The hearing officer found that Ms. Ariola had paid excess rent just in the amount of almost $2,500. The landlord appealed that decision because she believed that new evidence that she submitted with the appeal showed that the hearing officer had erred in her determination of Ms. Ariola's initial base rent, which was essential to her finding of excess rent. She also argued that state law preempted the finding of excess rent under the Civil Code. The board, however, no longer has jurisdiction over this property because the property has now been removed from the rental housing market under the Ellis Act, and the tenant has received relocation payments and moved out. As such, it can no longer consider the appeal, nor can it grant the withholding remedy that its regulations authorize it to do so. So the board does not need to take any further action in this matter.
Thank you very much. Okay, question to staff. Commissioner Foster.
So just for clarification, and maybe the public would be interested in understanding why the transfer of property or the acceptance of their fate in an Ellis situation removes the prior bad act.
Well, a transfer of the property doesn't. But if a property is Ellis, it then becomes, it's no longer a rental unit. And it is therefore, because it's not a rental unit, not subject to the board's jurisdiction. It's effectively exempt as a result of the Ellis. When a property is exempt for whatever reason, whether it's because of an owner occupancy exemption or some other reason, or in this case it's just removed from the rental market, the board is without authority to act.
Hang on one second. Any other questions, Commissioner Foster? No. Okay, Commissioner Trosis.
When was the notice for Ellis?
I believe that the property was removed from the Ellis Act just very recently, in the last several weeks, if not in the last month.
Are the U's here tonight?
No.
I have no request to speak.
Did they give you any indication that they were planning on doing this before they did so?
Sorry?
Did they give you any indication, the U's?
I'm sorry, I don't understand.
Miss U.
What is the
I'm
this?
assuming that Miss U is the owner. Am I incorrect?
That is correct.
Yeah.
And it's the this that I don't know.
Oh, sorry. Their intent to remove the property.
Yes, they had filed an Ellis Act before. They had filed a notice of intent to withdraw the units from the rental market, and the timing of the process wound up being such that the matter reached you after the Ellis had been completed.
Correct. But when they went to the hearing officer, was that already a known fact?
Yes.
Did we work with them at all to give them any sort of technical assistance to try to prevent that from happening?
I'm not quite sure what you mean by that, Commissioner.
I'm just trying to see if there's anything that we could have done to preserve the property. I know it's within their right to do so.
Yeah, the answer is no, and it would have been improper to do so.
Okay. It's unfortunate because we're losing, rent-controlled housing stock at this point, and we know that we're in a housing crisis here, and every single unit is precious, and we need to make sure that we preserve the diversity of the city. So I'm obviously dismayed to hear that.
Any other questions, Commissioner
No.
Trosis? Okay. Commissioner Phyllis.
I just want to be clear. The recommendation of staff is literally to strike two portions to affirm the findings of fact and conclusions of law, except delete paragraph 35, which is tenants in rental units are subject to the rent control law. And then 40, the clause in the lease agreement that purports to provide for separate billing of a proportionate share of shared meters costs is against public policy. I mean, this doesn't change the judgment.
If the matter were still within the board's jurisdiction, then yes, that's what we would be recommending. But it's not, so we're not making any recommendation now.
I don't understand why jurisdiction isn't assessed at the time the complaint is filed. That's how jurisdiction's assessed in federal court. That's how I just don't understand. It should be captured and not changed.
Here's the reason. Because the only remedy that the board has available to it is deduction from rent going forward. Unlike a court, which is able to award damages, the board is only able to provide a prospective remedy for a tenant that's still in place. That remedy is now not available.
So does this tenant have any remedy? I mean, I'm concerned about this, right? Like, does this mean, because we're on the public record, that any landlord who has this is what you were talking about, Commissioner Foster, any landlord who gets a massive judgment against them for an excess rent petition goes and Ellis the building and it goes away?
Not necessarily, no. I mean, tenants have civil rights, but the ability of the board to act ceases to exist when the property ceases to be under the board's jurisdiction. There are the board's remedies are cumulative with other civil or other remedies that may exist, but the board's ability, which is limited to ordering the withholding of rent, is a totally ineffective remedy when the tenant's no longer in place.
Yeah, I understand.
Okay, so I guess that being said, my question to staff is, we still move forward with affirming or denying the hearing officer's decision to.
No.
So
No,
there's-
we just, it's moot.
It's moot.
It's moot.
I have a question.
Okay. All right. So,
I have a question related to that, though.
no, I think that happens automatic. Okay, Commissioner Trosis, question.
Okay, let's say by some weird course of events, I know this probably would never happen, that the landlord changes their mind, and then they've decided, I don't want to proceed with Ellising this building.
Well, in this case, that's not an issue because the property has been Ellis. That we spoke with both the landlord and the tenant, and everyone's gone. I mean, it's
Wait.
the Ellis had we had notice of the Ellis a long time ago. The Ellis was complete as of a few weeks ago.
Okay.
So there's no one there
There's no-
paying
right.
rent.
So,
Right.
do you, okay.
Okay, so then to make a clean record, does it make sense then to have a vote as to whether we decide this issue is moot?
I think
based
we
on
need to. Justiciability?
If the board lacks jurisdiction, then there's nothing to vote on. But you can certainly
But don't we need to find that we lack jurisdiction?
you can do that. Yeah.
Yeah, to preserve a record of some sort. Okay.
Otherwise, it's just like.
Yeah. Okay. So then I would, well, help me out with this, council. Move that we find that this body no longer has jurisdiction because the case that was agendized is now moot.
I amend that. I don't know if this is legal, but I move that we find that had we had jurisdiction, we would have affirmed the hearing officer's decision, but at this point we lack jurisdiction and therefore the issue is moot.
That sounds like an advisory opinion.
I don't accept the amendment.
The simplest motion would be to vote that the board is taking no further action on the basis that the board lacks jurisdiction.
Okay. All right. That is my motion as stated by council. Is there a second?
Second.
Okay, first and second. Roll call vote.
Commissioner Trosis?
Reluctantly, yes.
Commissioner Foster?
Yes.
Commissioner Phillips?
Yes.
And Commissioner Duran?
Yes.
Motion carries.
Okay, moving on now to administrative items 12A. Consideration of whether to limit, phase out, or directly eliminate pass-throughs permitted under Regulation 3105, 3106, 3108, and 3109, respecting surcharges for local taxes and voted indebtedness. May we have a staff report? Oh, sure.
Yeah. While Mr. Gwynn is bringing, I have some visual aids. They're somewhat limited, but while Mr. Gwynn is bringing them up, I'll just apologize. I've already been. This apology comes late because I've already been talking, but I apologize for my croaky voice.
You're just croaky.
I am croaky. Okay, as Chair Duran mentioned, the subject matter is a board discussion about whether surcharges, which are for taxes and voted indebtedness, should be limited or eliminated in some way. At the board's last meeting, the board asked staff to come back at this meeting with some framework for considering this issue. And in its discussion, it raised a number of issues that it wanted staff to frame for the board to discuss this evening. Among those considerations were what is the entire universe of surcharges that are at issue? How do those surcharges affect rents? Does it make sense for all tenants to pay the surcharges? Does it make sense for all owners to be allowed to impose them? And if so, to what extent? How might surcharges be limited? And if they are limited, how can owners be protected from undue hardship? And finally, how should future taxes and voted indebtedness be handled? Before we get into these substantive issues, though, I wanted to just talk about some sort of foundational questions. And the most thoroughly foundational is, why do surcharges exist in the first place? Under former Charter Section 1805, the board was required to consider changes in local taxes when determining each year's general adjustment. The specific language was, each year the board shall generally adjust rents upward by granting landlords a utility and tax increase adjustment for actual increases in the city of Santa Monica for taxes and utilities. That's no longer the law. In 2002, the voters amended Section 1805 to simply provide for a straight 75% of the change in CPI. So the mechanism by which surcharges were permitted has been eliminated. So what does that change mean? Most basically, it eliminated the board's authority to allow for new surcharges. This is because the board's authority derives solely from the language of the charter, and it can neither expand nor contract its own authority. So, with respect to any new taxes approved by the voters on or after 2012, the board can't authorize a surcharge. So, going back to the specific issues that the board asked staff to talk about, the first is the universe of surcharges. Yes, I promise visual aid, so I see. The first surcharge is for schools, for the Unified School District and college bonds. The regulation that provides for the surcharge for those things is Regulation 3105, and in the language of the regulation, it's very limited what's included in that. The language of the regulation says that it includes school district special bond tax surcharge measure ES, that's supposed to be ES, not EX, which was passed by the voters in 1990, and a community college district special bond measure T, which was passed by the voters in 1992. In 2011, there was a lawsuit between the board and Action Apartment Association over the board's not including some of the surcharges that the charter specifically contemplated. And as a result of that settlement agreement, additional surcharges were added. Those were for, or surcharges weren't added, but the surcharge under Regulation 3105 was expanded to include the voted indebtedness and taxes for the following things. Measure X in 1998, Measure U in 2002, Measure S in 2004, Measure BB in 2006, and Measure AA in 2008. Not included are Measures ES, which were passed by the voter in 2002, and Measure V, which were passed by the voters in 2016. The reason is because those were not approved by the voters until after the voters had eliminated the board's authority to allow for surcharges. And so they disappeared into that black hole. Note also that existing surcharges for voted indebtedness will all eventually end as those bonds mature and are paid off. So right now there's that whole list of voted indebtedness, most of which are bonds, and they'll all be issued, paid for, and they will over time go away. No new ones are being added because of what we just discussed. The second thing in the universe of taxes and bonds are school and college, the school and college bond. I'm sorry, before we get to that, the median amount for the school and college bond surcharges is $14.09 per unit per month. It's important to realize that this is a median, though. It's not the amount that everybody's paying. About half of tenants are paying more than that, and half are paying less than that. So that again is a median. The second thing in the universe is the stormwater management fee, which is allowed by Regulation 3106. This is unaffected by property value. It's mostly affected by the size of a property and the number of units. The median surcharge for this is 76 cents per unit per month. It's a fairly low amount, but again, if there are fewer units in the building, it'll be more. If there are more units, it'll be lower. But that's the median. The other surcharge in the universe is clean beaches and parcel tax. That's permitted by Regulation 3108. This is also not affected by property values. The median of this is $2.15 per unit per month. Finally, we have the school district special tax. That's permitted by Regulation 3109. This is also not affected by property values. It's a flat amount. It was established by the city council at a given amount when it was first enacted, and it's been inflation adjusted. It's indexed for inflation, so it goes up every year, but every year it's the same amount per parcel. Currently, that amount is $396.23 per parcel. The median is $3.95 per unit per month. Obviously, the more units, given this is a per parcel tax, the smaller that will be. In the case of a Torquay unit, for example, it'll be pretty significant. So, back on Earth, what is the effect of these surcharges on rents? The weighted median of all surcharges, all the ones that we just talked about added together, is $20.85 per unit per month, or $250 per unit per year. But note, as we've been discussing throughout so far, buildings with fewer units, especially Torquay units, for example, where there's just one, or buildings that have recently sold, are going to have much higher surcharges. For Torquays, the school district special tax alone is $33 per unit per month. That's before the other ones are added. So it can be much greater than just the annual general. The annual general adjustment is a certain dollar amount, and the surcharges can be quite a bit more than that for a small building, especially one that's been recently reassessed. The next question that the board asked for a framework for discussing is whether all tenants should be required to pay the surcharges. In particular, the board asked about what about new tenants. With every new tenancy, the landlord has the right to establish a new rent. Presumably, when doing so, the landlord looks at what his or her overhead is and builds that into the rent. If a landlord is establishing a new rent at whatever rent they want and is then charging surcharges on top of that after having already figured their liabilities into the rent, they're effectively charging for the same thing twice. The other question that the board asked is, should all owners be able to impose surcharges? The two possibilities that the board talked about is the difference between long-term owners and people who have just newly purchased their properties. Long-term owners can make a credible argument that they relied upon the understanding that they would be able to pass through their surcharges. They would have built that into their financial planning and their thoughts. Note, though, as a caveat to that, even for long-term owners, that's not true. That reliance argument is not true with respect to new tenancies if they have the right to establish a new rent, because they can't claim to have relied upon the ability to pass through a surcharge if they're able to set the new rent at whatever amount they want. But as a general matter, for longer-term owners, they certainly can reasonably say that they had some degree of reliance upon the idea that they could pass through surcharges. With new owners, that's less true. They're making a financial decision based upon the facts and the law that apply at the time. So if surcharges are not permitted for new owners, then they can't say that they reasonably relied upon them. So when surcharges are allowed for landlords or tenants, how much should they be? That's the next question that the board asked for a framework for discussion. There are a number of policy considerations and rationales behind how this might shake out. One, which was already discussed, is public expectation. The other is, and this was discussed somewhat by both landlords and tenants at the last meeting, is who benefits from the underlying taxes and bonds for which these surcharges provide recompense to the owners. Landlords have often argued that it's the tenants who live in the city who benefit most directly, and as a matter of day-to-day living, that's no doubt true, although there certainly are landlords who also live in the city and they also benefit. But it's not true that landlords do not benefit from these various things, good schools, clean beaches, etc. All of those things add to increased property values, and to some extent, a landlord's benefit from those things is more lasting than a tenant's, because a tenant's benefit from those things will end when the tenant moves out, or if they move out of the city. An owner, if their property value goes up and they sell their building, they still keep that cash. It's not like somebody takes it away from them. All right, so what are possible ways that surcharges could be shared or distributed? This is a continuation of what we were just discussing before. When surcharges are allowed, how much should they be? One possibility is that the owner is able to recoup only 50% of their building's total taxes and voted indebtedness as a surcharge, and pass through the other 50% on an equal basis to all of their tenants. So taking the median, the $20.85 per month, per unit per month in a 6-unit property, for example, it would work like this. The owners retaining 50% of that liability for themselves and passing through half of it to their tenants. The other half, the remaining $10.43, is evenly divided among the 6 units, and it looks like this. So $10.43 that the owner does not pass through, and then for the 6 units, they pass through $2.09 per unit, adding up to the same amount that the owner is retaining for himself or herself. Another possibility is that the owner retains only responsibility ultimately for the same share that they're passing through to their tenants. So, for example, taking again the $20.85 per unit per month median, in a 6-unit building, you would divide by 7. So that would look like this. The owner would pay $2.98, and all of the tenants would also pay $2.98. Of course, the owner is paying the entire amount, but then they're passing through as a surcharge this $2.98. Do you understand what I'm saying?
Yeah.
Okay. I'm just using this as the median. Yeah. Again, as I mentioned before, for some properties, the per unit surcharge will be much higher, and for some will be much lower. This is the exact in between.
Can you explain why that surcharge would be much higher?
Yes, as I mentioned earlier in my remarks, if a property has been recently reassessed because it's been sold or for another reason, that would make the surcharges higher, because a good percentage of these surcharges now result from the first thing in the universe that we talked about, which are based upon the assessed value of the property. The other factor that dramatically affects the amount of the surcharge on a per unit basis is the number of units in a property.
Right.
So if there were a long-term owner of a property with 40 units, the per unit surcharge is going to be relatively small, because the assessment will be from a long time ago and it'll be divided by 40 units. If there is a 3 or 4 unit property that was just recently sold for a lot of money, that's divided by a smaller number of units, and the amount that's being divided among those smaller number of units is a higher number.
So theoretically, the surcharges would be wildly disparate and
Yes.
not means tested.
Yes, they're not means tested.
Thanks.
Yeah.
And just to be clear, the key driver for rapid increases we've never seen, these surcharges will never go down, right? Because you can never add a unit, really. Generally speaking, you can't add a unit. And you're not going to see assessments, unless we're really in trouble. Like, you're not going to see these assessments go down.
Well, yes and no. In the short term, definitely yes.
Yeah.
In the long term, I don't think that's true, because, as I mentioned earlier in my remarks, eventually these bonds are all going to, the big thing that's affected is the bonds, and those will all be paid off over time. But that's not going to happen in the next year or two. That's
what's
years.
the timeline?
I don't really know, because I don't know to what extent all of the bonds that are included have been fully sold. I mean, there are bonds that were passed a long time ago that they're still issuing new, that they're still selling new bonds on. So I don't know the answer to that question.
Do we have any historical data on when certain bonds have been fulfilled?
It really varies upon a variety of factors that make how it happened in the past not that relevant, including how much the total bond was and what they're using it for and how the needs for those things arise. It's hard to say, but I don't as I sit here now, even given the limited utility of that information, I don't have it.
Can you ballpark it? Like, are we talking about 10 years, 20 years, 1 year, 2 year, 5 years, 6 years?
In the staff report that we provided for the last meeting, we itemized what the current allocation is within the line item on an owner's tax bill to come up with one factor. The Measure ES bonds for the school district that were originally approved in 1990, they still contribute 12.3% of that total allocation. They'll be retired, I think, 20 years from 1990. Measure X from 1998.
Then they would have already been retired.
No, in 2020.
In 2020.
Yep.
So 30 years.
That was 30 years, right? Measure X contributes, which was approved in 1998, contributes 13.21%. Measure BB, approved in 2006, contributes 37.11%, and they have refinanced a number of bonds within that, sold a number of different series. There are 8 different components to the Measure 2006 bonds at this time. And Measure ES, which was approved in 2012, currently contributes 37.38%.
So this is like a revolving thing. I mean, for most of these, I'm not seeing an end in sight, and I think we kind of have to operate on that assumption, unless there's a reason why council can say that's wrong.
No, it's true. I'm just saying that you just said that they're never going to go away, and I say it's not true that they're never going to go away, but it's not going to happen anytime soon.
Yeah, I mean, it's like lifetimes, potentially.
For a couple of them, they're going to go away in 2020, but the bulk of them are going to be going on for quite a long time.
Yeah.
Okay. So the board asked for consideration of possible other limitations on surcharges. One of those is a dollar amount cap. The question is, if the board were to impose a dollar amount cap, what would that be? It certainly can't be a figure that's just plucked out of thin air. It's got to be based on something. One possibility is the current median of $20.85. Whether that ultimately is the correct number or there's some other factor to consider, I'm not sure. But that is one rational possibility. But if the board were to impose a cap, it would want to think about what is the basis for that cap. Another possibility is some division, half or something else, of the current median. So previously I mentioned various ways that the surcharges can be shared between landlords and tenants. This isn't a situation in which you have to pick one of these things we're talking about. There could be some combination of them, including a sharing of them and also a division of them, a division of the total amount, or a sharing of them and a cap or something. There could also be a cap based upon a percentage of each unit's MAR. In other words, the maximum allowable rent as a result of a surcharge can't go up by, for example, more than 1.2%. I picked 1.2% because that's a percentage that most closely tracks with the median dollar amount of $20.85, but there's nothing magical about that particular percentage. Possible additional limitations are a one-time increase in maximum allowable rents equal to surcharges per unit up to a specified cap, and then all the other surcharges are just repealed. If that happened, it's important to understand that there would be a cumulative effect because it would be rolled into the MAR, and every time a general adjustment was added, it would be added on top of that. Another possibility, as we discussed previously, was no surcharges for new tenancies. This will result in surcharges eventually being phased out as units turn over, and at some point we will have a situation in which every unit will have turned over. The other possibility is no surcharges at all for new owners, as discussed previously, and this too will eventually result in surcharges being phased out. And there's no reason why there couldn't be some combination of these things. The final question that the board asked for a framework for considering is, what about future taxes and voted indebtedness? As discussed at the beginning of my remarks, the board can't, by its own action, just allow for future surcharges because it's not something that the charter permits. So the charter could be amended to permit it. That's one possibility. The other possibility is that voters, in voting for voted indebtedness or new taxes, can specify in the ballot measure that a percentage or a dollar amount or the whole amount or whatever can be passed through. So that would be actually an action of the voters and would not require board action. One advantage of this is there would be total transparency because everybody would know exactly what they were voting for and what they were getting into or not getting into. One disadvantage, which is not to be discounted, is that there is a boundary issue because for the community college district and for the unified school district, the people voting on these things don't all live in the city of Santa Monica. And so there is a possibility of people voting to allow or not allow the pass-through of these things who aren't going to be affected by it. So that idea, which is used in San Francisco, may not be a spectacular idea here in Santa Monica. At least one board member asked what other jurisdictions do with respect to surcharges, and there's really only one that does anything. That is San Francisco, and it allows them, if specifically permitted by voters in the ballot measure, as we just discussed a minute ago. That's an easy thing for them to do because the county and city are coterminous, and there's no boundary issue there. And that's it. That's the only jurisdiction that provides for any other sort of surcharge. We're unique outside of San Francisco in doing this. So that is the conclusion of my remarks. Thank you very much. And again, I apologize for my croaky voice.
That's fine. I have 3 requests to speak. I was waiting for a big send-off at the end, though, and it was just a blank screen. So, the first we have Nani Granell, and Ms. Granell has asked for 3 minutes. Whenever you're ready.
Thank you. Do I turn something on?
No, it's all set. You're ready whenever you are.
Good evening.
Good evening.
I've appeared before the board a few times, and I have to tell you, I'm still horrified by these tax surcharge pass-throughs. And, listening to the explanation just now, it's very interesting, and there's a lot of possibilities. However, median doesn't mean anything to me. Not a thing. Because the median is $20.83. And my tax surcharge monthly, not including my rental increase or anything like that, is $121.83. And that's almost $1,500 a year. And it has nothing to do with median. So what do we do about this? And I'm grateful that you're looking into it and that, people are interested, but I am just horrified. And another thing is that I was never told when I moved to Santa Monica that I would have to pay any tax surcharge. There's nothing in my lease, and everyone in my building, some there as much as 30 years, has never seen a tax pass-through, a tax surcharge pass-through. So, first of all, I was in complete shock when I got the MAR. Yes, there was something in the 2016 MAR, but I was going through a terrible time at the time. My husband was dying, and I didn't pay attention to it, but it was $30. Okay, that's a lot of money too. It wasn't $121. And you worry about owners depending on the tax pass-through? Well, I can't possibly have any kind of compassion for my owner because, I mean, he's raising rents as soon as someone moves out from $1,500 to $10,000. And can I have any kind of compassion for that? So, do I have to worry about him not having enough money to pay his own taxes? And another thing, there are waivers in your documents online saying there's a waiver for this, there's a waiver for that, low-income owner, low-income tenant. Well, you know, what about us old folk? What about us 70-year-olds who can't afford the $121 a month? Thank you so much.
Thank you very much. I now have Ms. Lori Brown. Commissioner Brown, you've requested 3 minutes.
Good evening, Commissioners. Good evening, Commissioners and Chair. Pass-throughs. I don't want to pay them. My tax bills are incredible. My bills are out of the roof. I don't pay $4,500 in rent. And I don't have a building that I could just decide $4,500 for rent. When you make a statement, and by the way, I really liked the presentation you made because the first thing was space. So I live in reality. I really do. And when I see my tax bills, I can't afford to pay them. I struggle. And now you're telling me that I'm going to have to pay the tenants as well? We don't make a lot of money. I think that somehow landlords assume that we make a lot of money, but we don't. We're not responsible when a building turns over that the tax man says it's a higher fee. $20 a month to the tenant is just as much as $20 a month to me. It affects my bottom line as it affects everybody else. I come here, and every time I come here, it seems that, well, let's put a cap on putting something on the landlords. I also sit here and see buildings disappearing. And you can't put two and two together. Everybody in this town gets a right to vote for that college bond. Personally, I didn't vote for the college bond because I couldn't afford it. But if my tenants could say, hey, yay, let's just vote for a college bond because they're not going to pay for it, that's unfair. And I think pretty undemocratic. I'm not as smart as you guys. I'm not as well-breast in the law. But what I am is a business owner, a small property owner, and I'm being hurt every single time I turn around. Not you. If I don't get my bill in on time, if I don't pay my bill on time, I can't even put that pass-through in. The pass-throughs, this is what other people voted for. This is what you voted for. And now you're going to sit there and decide, well, only a certain percentage of people should pay for it? Did you give that when you were making your vote for the college bond or the school bond? Did you sit there and think about that? Well, let's see. The landlord should pick up the burden of it. I won't have to pick up the burden of it if I'm a tenant. It's a burden that we all have to share. Everything is being raised across the board, everywhere and everything. And I think it's about time that you took a look and not realize that we're enemies, that we're partners here. And then the more that you realize that we're both human beings with both expenses, whether they're a landlord who's old and had the building for a long time, or a new landlord. When they say the city of Santa Monica is difficult to do business with, and I shrugged it off, I'm really eating those words. You're really difficult to do business with. And it would be a shame if I had to turn my building into a place where I had to live because I could no longer afford it from getting getting my rents. And this magic number of I just get to pick a number when an apartment goes vacant is a joke. I read it every single day of what rates are. I don't get to pick. It's based upon what the community is willing to pay.
Thank you, Commissioner Brown. Oh, you do? Okay. I'm sorry. Commissioner Brown, Commissioner Terosas has a question for you.
Do you think, or what do you say to the argument that by passing these bonds and improving our schools, you're saying you don't get to choose what the rent is, but that we're driving up housing prices in the city by creating a great place to live with great schools and parks and beaches and amenities?
Well, the question will be great schools and great beaches is something else. But I can tell you that the tenants that are moving in are not people who are concerned with the great schools.
So that it doesn't increase your the value of your rent?
Nothing increases the value of my rent. You know what increases the value of my building? Determining how many rent-controlled tenants I have in it, period. That's what is the value of my building. How many rent-controlled tenants I have. If I have none, my building goes up. Take a look at what you read, because I could look at buildings today and see what I can afford to buy and what I can afford to buy versus what the rents are being paid. So you'll wait until somebody else can come in and buy the building and buy it out and put up condominiums and get rid of your tenants. So I disagree with that statement that our city is providing such fantastic amenities that that my building is worth more.
Okay, thanks for your comments.
Thank you, Commissioner Brown. I now have Elaine Golden-Gieler, and she has no video, but she does have a PowerPoint, so it'll take just a moment. Set that up.
Right. Okay, I hope City TV is watching. Thank you very much. In your staff report, you failed to mention the working solution you already have in place for pass-throughs. In 1979, there were 33,000 rentals in Santa Monica. Today, there are 26,000 rentals. Congratulations. 7,000 tenants no longer have to pay pass-throughs. Well done. Little by little, your policies are not only eliminating pass-throughs, but also small mom-and-pop property owners as well. In the short run, tenants will save money. But in the long run, owners will save even more. Because from now on, Santa Monica bond measures will never get enough votes to pass. Promises were made to secure our votes. Attention, SMER. We will never forgive or forget. Thank you.
Thank you, Ms. Golden-Gieler. Okay, there are no more requests to speak, so I will open it up to discussion. I have Commissioner Phyllis on cue first.
Thank you, Commissioner Duran. Thank you, Stephen, for a great staff report. This is a really difficult issue that I think addresses or kind of raises multiple concerns for tenants and for landlords and for our community that probably will have to be dealt with over the course of several meetings. And the approach that I'm going to propose is a phased approach. So I want to address kind of the immediate concern, or my most immediate concern, and I believe I hope that it will appeal to my fellow commissioners. And then I want to kind of propose more long-term concerns that I think will require more contribution from the community, particularly stakeholders, both landlords and tenants, and our schools and our colleges, because we want to make sure that we're balancing the interests of being able to support our excellent schools and our excellent beaches and our excellent community college, while also making sure that tenants aren't losing their homes and landlords aren't being forced to go out of the rental business or feeling compelled to go out of the rental business, because whether they feel compelled or they financially can't make ends meet, we're losing these properties. And I think it's important to make sure that we are facilitating ownership. So my first priority, and I think this was raised when I when we started hearing from tenants, particularly this year, about massive surcharge increases, is what happens when a building turns over. And I just want to be really clear to members of the public what specifically I'm talking about. So these measures that we've passed through, the voter indebtedness passed through, so those are the college bonds and the school bonds, are based upon the assessed value of property. Now, because of Prop 13, the assessed value of property will remain relatively stable with, incremental increases until the property is turned over. When the property has a new owner, we're seeing massive assessments going from a property that may be a 6-unit rental property held, on Montana that was originally assessed for $500,000 going for $10 million, $20 million. And because the the bonds or the voter indebtedness measures are based on those property values, you're seeing, original dollar amounts that were, a couple dollars every month to $30, $40, $50, which is, I believe, the exact situation of our first speaker. That property was held by an owner for a fairly long time, and then it turned over. There was a massive increase in the reassessed value, and because of that, the tenants who literally had no notice or control over whether their building would be turned over were stuck with this massive tax increase. Now, I also am sympathetic to what we've heard from landlords, that landlords, in coming up with the deal that they've made in acquiring these properties, have relied upon the fact, presumably, if they've done their diligence, on the fact that they will likely be able to pass certain measures through, whether it's these bonds or these parcel taxes, which to me, honestly, I am much less concerned about these parcel taxes because they just aren't subject to the massive increases that we're seeing for the voted indebtedness measures. If we're talking about like what I am most concerned about in terms of order of priority, it is the voter indebtedness, because that is where we're seeing people lose their homes because they cannot afford hundreds of dollar increases, especially seniors, especially folks on fixed budgets. So that is the primary problem that I'm concerned with. And the solution that I envision and the solution that I want staff to address has two components. First is, I think we need to sunset the passing through of voter indebtedness. And what I mean by that is, okay, landlords, we hear that you have relied upon the idea that you will be able to pass through these bonds to your tenants, right? We hear that, we are understanding of that. If you have notice from this point moving forward, or really the point of a public hearing, which I'm going to ask be set on a special meeting because I think this is a crisis level at this point, you will, or future landlords or future owners, right? So none of our current landlords, but future owners will be able to negotiate in their purchase price a price that reflects the fact that they will no longer be able to pass through voter indebtedness. That is my first, or pass-throughs altogether. And I want staff to address both if we sunset just voter indebtedness or if we sunset pass-throughs altogether for new landlords, right? Is that clear? Okay. That is like an order of first priority because we have heard multiple tenants come and say, I didn't see this coming, I can't afford this, I'm going to lose my rent control apartment, where we're literally capping increases at, what was it, $40, $25? What was our cap this year? 40, right? And they're saying, well, my increase already went up, 3 times that just because of the pass-throughs. This is madness. It needs to stop, and we need to address it as soon as possible. The second point is, I think for new tenancies, right? Again, where both the tenant and the landlord will be on notice, we need to rethink pass-throughs as well. And I think in that circumstance, just like with new owners, with new tenants, if you are operating on a clear assumption that you will not be able to pass anything through, then you can address increases in the rent that you sent for the tenant. Now, I think this actually makes sense because the landlord is negotiating a lease with the tenant. The landlord presumably is assuming that they're going to be there, for a fairly long period of time. So it's not going to hurt the landlord as long as they keep the property in their name. They're not going to get stuck with massive tax increases because they're going to have, this incrementally increased assessed value. So I think my primary concern, and I think the first order of business for this board, should be sunsetting pass-throughs for new owners and sunsetting pass-throughs for new tenancies. Now, in terms of a long-term solution, I think we need to be much more mindful about the way that it could potentially affect funding for existing bond measures, particularly ES and V. Those the two ones that have passed since 2012, where they are kind of in this in-between zone, where they have been currently passed through at 100% post-GA, but GA really doesn't have authorizing language to permit. We need to address that, right? But I think that's a trickier solution where we need to hear from more stakeholders and really think about how is this going to affect the community and who really is suffering harm here from these pass-throughs. Because I think, the primary concern right now is really these voter indebtedness measures when the buildings turn over. So my proposal is we phase the potential capping, limiting of a pass-through for future meetings. I think that's going to require multiple public hearings. I think it's way too difficult of an issue to address at the same time. And I think really like the crisis level problem is something that we can address in the next 2 weeks. So I'm going to propose that we set a special meeting in the next 2 weeks on the sunsetting provisions that I just said. So sunsetting of pass-throughs for new tenants and new owners. And I want it to be a public hearing with proposed regulation amendments so that we can adopt something right now. Because I swear, if I hear another tenant going through what we've heard about today, it's just too much, and we can't continue to countenance it. So I would ask for my board member support, and I welcome any feedback, but to me, that's really the driving force of this entire item.
Okay, thank you very much.
Do we need to vote, or is that
well
on the public on the special? Or we
let me
table the item, or not table it, but.
Why don't we wait to the rest of the other people already have talked?
Do I need to make a motion to set? Can I make a motion to set the special meeting and continue the?
Well, you can do that, but first let's finish our discussion, and then I'll entertain a motion, and you can make it then.
Okay.
Okay. Commissioner Foster.
Thank you. I certainly agree with Commissioner Phyllis that this is going to take more than one meeting to parcel out some of the different categories of issues and different timelines of issues. I agree. There are three categories of timelines I want to keep in mind when we're framing things. One is pre-2012. One is 2012 until today, or until such time as regulatory action would be taken or voted upon, and then from that point forward. So I agree, and I'm going to support a motion to have the special meeting on January 25th, which is one of our regular meeting slots, so that we can address and get this action going sooner rather than later. That has my full support. Also, I'd like to take the data that you gathered for the December meeting, where you started to analyze some of the buildings that turned over after 2012, and so that the public understands, the reason I'm choosing 2012 is that's when the law changed. And the lawsuit that you mentioned in your staff report last month did say in the settlement language, if and until Chapter 1805, I forget which part, changes, and it did. So I think we'll all need to get much more public input from stakeholders, landlords, tenants, schools, colleges, any interested tenants, citizens of the city of Santa Monica, and any stakeholders as to what to do, if anything, about past pass-throughs, some of which had very specific functions, and some which we're not really sure. So I'd like to look and see if we were to pass a regulation governing what happens from this point forward, what about the people like the public speaker? What about the people suffering from the exact same thing, but from 2012 till today? I don't want to go back too far in time, but I do think we have a right to at least examine from a staff's perspective what we could potentially do for 2012 forward in regards to buildings that have turned over. And I wanted to offer a friendly suggestion to Commissioner Phyllis's matters, that it not only be building turnover, but any voluntary massive rehabilitations that were voluntary, because that could trigger a major, and we've had constituents write us letters in the past about that situation, a massive gut rehabilitation, also a voluntary rehabilitation, also triggering a massive reassessment. So I wouldn't limit it to just simply selling, but also to
just to make sure that I'm, because I want to make sure that I'm preparing the right thing for for 2 weeks from now, if that happens. Are the issues that you're talking about now, are they for 2 weeks from now to be discussed as well? So
at least for 2 weeks from now, at least the caveat to add or any voluntary major rehabs that trigger a massive reassessment in the same exact spirit of a building turning over.
Like an orders of magnitude reassessment. I mean, I'm not talking about like a 10 grand reassessment. I'm talking about like a 10 times.
So perhaps staff could suggest a threshold or a couple of examples of thresholds that would make sense, or a triggering event category that would make sense. I'm asking for help with that language. So the public understands there's absolutely no doubt that this is an issue. And all of us have been studying our staff reports for the last couple of months, and we've been studying the charter and studying the changes in GA and studying the past provisions and how all these things came around. The charter allows us to do two things. One is regulate rents according to the charter, and one is to guarantee at least a fair return, but no more than a fair return to landlords. So it no longer specifically says we have to pass through or take into account property taxes in the GA. The GA has its own mathematical formula that the voters of Santa Monica passed, not that we passed, but that the voters passed. So I'm trying to be cognizant of what our charter allows us to do going forward, and potentially from 2012 going forward. I do think for next month's meeting, I, for one, would like to, and hopefully with other commissioners' support, ask staff to bring back further data about the past pass-throughs, pre-2011, or pre-2012, I'm sorry, pre-2012. I am also concerned that landlords set rents and bought and sold buildings with the understanding that they could do this. But I also understand that it was, it's been sporadically addressed. So I'm I'm looking for more information about the past and how that might shape any, because staff has indicated that we potentially could do something about past pass-throughs, but I'm not certain we can or should or would. I'm looking for more data. I don't have enough information to make that determination at this point. And so looking at those 3 time periods, I want to look at more carefully. And the median, I wasn't satisfied with a $20.83 median, because you can have 3 different sets of scenarios for both tenants and landlords. You can have a long-term landlord of 30 or 40 years. You could have a medium-term owner of 10 or 12 years. And you can have a brand new owner. You could who's buying at this high market, at the top of the market. You could also have long-term tenants, medium-term tenants, and short-term tenants who are taking on different burdens of these pass-throughs. So using a median is tough, because I don't think it takes into account the wild variances that you acknowledged, that you talked about. $5 pass-throughs or literally $400 pass-throughs for some Torca residents. And the reason we passed the info sheet this past year was because new tenants will now be advised that they should at least have this conversation with their landlord, because landlords were not necessarily compelled to have this conversation with them when they signed leases up until the information sheet. And I firmly said, I believe when we passed that people have a right to know what they're entering into. So it's not that anyone's looking to undo or redo, or it's that we want to be true to the law, and we want to honor the contracts that we're supposed to be overseeing. You know, we're not supposed to be having jurisdiction over the lease like we heard in that one appeal, but at the same time, we are adjudicating what happens after that lease to those dollar amounts. So I just want to make certain that people know that a MAR plus a registration fee plus a surcharge, you know, we just need to be clear. And so I agree with Commissioner Phyllis about the future, about setting, and I just want to elaborate on that. It'll be the last thing I talk about. So the reason I'm supportive, at least for bringing regulation language back that we can study next week or in the next meeting, of protecting or not protecting, sorry, which the new tenancies. Sorry, I couldn't think of what I was trying to say. For the new tenancies, so let's say building A has one unit paying $500. They're all one bedrooms. One's paying $500. Two are paying $1,850, and one's paying $2,100. And somebody that in that $1,850 apartment moves out, and they get $2,350 for it. What they have the opportunity to do when that person moves out, that $1,850 moves out, is say, I know that last year my property tax bill was this. And I know that divided, you know, that this is what it costs, and that this is what I get to pass through, or now not pass through, maybe, as the case may be. They can say that might be a total of $600. They might be able to recoup most or all of that in one resetting of one unit. So their opportunity is to do that. And our own annual report noted that after a unit turns over from one long-term tenant, it turns over on an average of every 3 to 4 years. So that means every 3 to 4 years, a landlord has the potential to add new charges or expenses they encounter into that next person's new rent. So I think that's, for clarification, that's what they should have the ability to ascertain their property tax liability and put that into that next unit's rent. That's all I have for now. I think we have miles to go before we sleep, and to get through this with the public's help and input. Thank you.
Thank you very much. It's okay. Commissioner Trosis.
Okay, I just want to thank staff for going to that level of detail now for the last 2 months, and thank you for the great presentation. I appreciated the visual aids. I'm a visual learner, so thanks. I think that housing affordability is kind of a regional and statewide crisis. We know that. We're in agreement with that. I think even the landlord community, Mr. Millman has come here and opined that he's here to be a good landlord for our tenants, and I think good landlords make happy tenants. So I think this is an incredibly difficult issue. We want to have partners on both sides. I hope that we've conveyed to you that we want to hear from all of the stakeholders. I know that I certainly have personally said that. But I think we have to do, and we've been elected to do, what is in the best interests of our constituents. And I think a compromise is not something that leaves everyone happy 100% of the time. But we're doing the best that we can by the most people here. So with that being said, I of course don't think that we can make a decision quickly or lightly on this issue. I absolutely support coming back in 2 weeks and studying some potential regulations here. And of course, I do say this with all sincerity, that I want to hear from our stakeholders in the landlord and tenant community, because I certainly think that a lot of you have been at this a lot longer than we have and have valuable insight that we'd like to hear from. With that being said, I go to work every day and I'm paid to do a job that I love. And I think that landlords go into this. It's a business decision, and hopefully one where it's not a charity. You're there to potentially earn a living or earn some money. And hopefully when you're a landlord and you're deciding whether or not to purchase a building and where that building is going to be, you have a financial advisor, you put together a pro forma, and you decide, how am I going to make money off of this purchase? So I certainly understand that we have a lot of small businesses here, long-term landlords, where they have been relying on these pass-throughs. And I hear that, and that's why I'm supportive of looking at this on a going forward basis. I don't think it's fair to all of a sudden come in at the 11th hour and say, oh, we're changing it up after you've made this business decision, and we're making a wholesale change here. But I do think that it's fair if new landlords coming into this community making a decision get to have the benefit of having the information that they will not be passing through any of the voter indebtedness bonds. And then they can make that business decision. Does it make sense for me to purchase this building? So great. That potentially might address a going forward solution. I'm not saying that's the right solution. I think there's still some legal issues to consider, and we'd have to look at some language. But then what do we do about our friends and neighbors and long-term tenants in this community who have just had buildings turn over and are experiencing these $120 a month increases? I think that there needs to be some sort of hardship test for people who have seen an increase. I don't know how far back we would go. I don't know if this is a post-2012 issue, but to me, I kind of look at it from a two-pronged approach. One, have you had a rent increase that's over X percentage per month? I don't know what that percentage would be yet. I was thinking in my head something like 15%, maybe it's 10%. I think we need some more reasoning around what's a logical number over X percent. And then I asked a couple meetings ago to come back with some definition around rent-burdened tenants. I think like industry standard would say if you're spending more than a third of your income on rent, you are rent-burdened. So I think we don't want people who are on fixed incomes to all of a sudden have, and especially seniors and people who have contributed to this community for years and years, to have, 120%, rent increase. I don't know, some ridiculous rent increase, and it's much more than a third of their monthly income. So I would like to see like a percentage increase coupled with a means test to see, is this a hardship for you? And then what would a process be by which you could petition to the board for a rent decrease or a surcharge decrease based on that hardship? I'm probably not being eloquent, but I think that people who have been experiencing these surcharges, and we know that real estate speculation is on the rise, and we know that people have already experienced this. We have to have a solution for people, not just on a going forward basis, but our friends and neighbors who have already experienced this. And I would like to see a quick implementation of this, because I fear that we are at risk of losing long-term tenants because of these turnovers in property values. And again, I'm not talking about the people who are, and I know landlords have come to us and said, we have tenants who are making tons of money and they're crying about these increases. No, I'm talking about a two-pronged approach where we have a rent increase over X percentage with taking into account the surcharges plus some sort of means test, like AKA you are a rent burden tenant. So I would like to see something around that as well.
Yes, go ahead.
If the board is interested in this idea of a hardship for rent-burdened tenants, are you talking about low-income tenants or tenants of a certain income level or any tenant? Generally, when we talk about some sort of hardship provision, it's for people of low income. The board itself has waived the registration fees for low-income seniors and disabled tenants.
Right, but I think this takes this a little bit further because we're talking about increases via surcharges such that you are all of a sudden going from spending X amount to now over a third of your monthly income just on rent. And not just that, and you've had a rent increase of like more than 15%, for example. If we're like, instead of at like a 1 to 3% increase. We're at like over 15% as a result of this surcharge. So I'm saying like a two-pronged approach. I don't know. Can anyone explain that? Does anyone understand what I'm saying?
Well,
I understand what you're saying.
Yeah, I understand that, but I just wanted clarity as to whether you were focusing on the income of the tenant. It sounds like no.
Not necessarily.
So I think it's a little confusing. So if I can just,
sure.
I don't think we really mean means testing as much as we mean looking at the the impact on the tenant.
Yeah, impact.
Right.
Thank you.
Yeah.
Yes.
So that is good.
Yeah. Great.
But I mean, really, like, the purpose of rent control is to make sure that your rent doesn't go up more than a ton.
Exactly.
You know, if this is getting completely annihilated because landlords are choosing to sell their buildings and choosing to cash out their equity that has been built in part by good schools, clean beaches, good community college. Tenants have no control over that. They don't get to capitalize on cashing out that equity. I think
Yeah, I mean, I think the whole purpose of rent control is so that people are afforded some level of stability so that they can be assured that they can dig in and contribute to this community and stay in a place where they have some sort of level of predictability of a rent increase. And if you have an over 15% rent increase as a result of a surcharge, probably because the property was sold, plus you're spending over a third of your monthly income on rent, those are the two together simultaneous things. I think we have a major problem, and I'm not looking to just what is your monthly income.
And I think it violates the spirit and the law of rent control.
Exactly.
Period.
And again, I'm hoping, and I've thought a lot about this, that this is being done in a way that's fair to both landlords and tenants, that we're not pulling any surprises for anyone here.
May I ask a clarifying question?
Yeah.
Again, because although the board hasn't decided on anything yet, we're talking about a meeting in 2 weeks, and then there would be another meeting 2 weeks after that. Is what you're talking about, if we were to do a phased approach, are you talking about regulatory language for that as well in 2 weeks? And I ask because that is a potentially highly complex.
Yes, I forgot to mention that point. At the beginning, I was going to say, is any of this reasonable?
Well, I don't know. I mean, the where it's coming from is certainly reasonable, but
No,
how we would deal with
get
it
it together?
in 2 weeks, no.
Right.
No,
yeah.
that's not.
I figure that this is regulatorily complex and it's fraught with potential legal challenges. And if we need more time, we need more time. But then also maybe can we flesh out some additional points in 2 weeks that would help move the ball forward? I would like to do that.
Okay.
I implore my fellow commissioners, please prioritize the sunsetting of pass-throughs for new owners and new tenants in 2 weeks, and then we can also perhaps have a study session on these long term. But I think I've said crisis before. I do think we're at crisis levels, and I think we really need to implement that limitation effective. The day that we pass it.
Yeah.
To stop the hemorrhaging.
You have the floor. Is that all you wanted to comment?
Can I make a motion, please? For just the special meeting.
Um,
not to close the item. I'm sorry. Not to close the item, but.
Okay, not to close the item, but for your special meeting, yes.
Yeah.
Go ahead.
Okay.
Just to clarify.
Wait, what happened to my special meeting?
Just to clarify.
It's all not on Saturday.
It wouldn't actually be a special meeting because it's a regular meeting.
Additional meeting.
Right, and that's an important distinction because of Brown Act noticing requirements and the scope of what can be discussed. So the way to, if the board wants to have this in 2 weeks, you can talk about it and come to a consensus, and if so, when we convene, when the board adjourns, it can adjourn until, just like it normally does, and state what the next meeting is. Because in the charter, that is already a regular meeting date.
Okay,
Yeah.
so I move that we hold a regularly noticed meeting under the Brown Act on Thursday, January 25th at 7 p.m. for the purpose of holding a public hearing on the...
Two possible regulations?
Yeah, whether we need to do it as one regulatory amendment or two I don't really care. But I would like it to address two items. One is the sunsetting of pass-throughs for new owners, and I want staff to also think of an implementation device. I think that would require some sort of registration of existing pass-throughs to make sure that landlords are protected, or somehow making sure that landlords, the current landlords who have pass-throughs, who are on, I mean, I don't know, maybe we don't need to do it. I just want to make sure that the current landlords who are current passing things through are not somehow concerned about losing their pass-throughs, that there's some record of who has
Well, it wouldn't have
pass-throughs
been addressed
as
yet.
of the date
Right.
we passed the amended regulations.
I think we can deal with that through clear legislative drafting about who's covered. and
Okay,
who's
so
not.
just really that the implementing mechanism is something that's also kind of at the front of my mind. And then for the second, no pass-throughs for new tenancies, which will mean I would like to see a new spreadsheet for post January 25th, 2018 tenancies. You know, the spreadsheet with the way that you calculate your MAR?
Oh, you mean the
Yes.
The worksheet.
The worksheet.
And I would like to see some.
Wait a minute. Is that
Which is
you're done with
which
your
is
motion?
probably like really easy. You probably just delete the pass-through section, but
Okay.
So you want to see how we would change
Yeah.
that form?
So that is your motion.
that is my motion.
Okay.
Is there a friendly amendment from my?
Yeah, I mean, not for 2 weeks from now, but I would like in short order, potentially in a month, that there's some initial proposals for this hardship test based on existing pass-throughs.
Does
I'd
that
be
pertain
open
to
to
her
a,
motion?
I'd be open to a study session on the same day as the public hearing on these forward-looking ways to address pass-throughs in the long term, including caps or any of hardship
Not
caps and
necessarily,
hardships.
yeah.
Caps and hardship tests.
Whatever the options are.
Based on impact.
If we do a study session, I just want to be clear that it's unlikely that I'll be able to produce a staff report that is. If the board wants to do a study session because it has its own ideas, then that's certainly workable.
Maybe it would be like a
But-
brainstorm session.
Yeah, but
Okay.
but I just want to be clear that
And more
I would
public
not be
input.
able.
Yeah, that's
to
fine.
do both.
But
of these
another
things.
PowerPoint, though. Just kidding.
Okay.
Commissioner Trosis, you were talking about the hardship idea for a meeting after January 25th.
I mean, I kind of wanted to start talking about it at the meeting in 2 weeks from now with a more thought out approach.
But not a public hearing.
Right. A study session.
Yes.
Yes.
Is that something that can be done? Council
You don't
staff?
have to come up with anything really substantial. Maybe Haka can help you. No, I'm kidding. I'm totally kidding.
Sorry.
Also, I'd like to include the portion regarding the current landlords and the concerns that we've heard about whether what the assessments are giving them a fair return on their I want to make sure that we're also considering hardship perhaps for those landlords who are the good landlords who've been there a long time, and maybe we can figure out a list of criteria as to what defines
But isn't
a
it
good
like a
landlord.
fair return petition for a rent increase based on fair return on investment? Yeah. I mean,
I want to make
but maybe
sure.
from a technical assistance perspective, if we can help landlords.
Perhaps that, and maybe what other options if they are in dire straits of getting out of the rental market because of losing pass-throughs, or we should consider that segment of the population as well. So I just don't want them to go undiscussed.
Yeah, no, I agree.
Make sense? Okay. So I would like to include that for the discussion in 2 weeks.
At the study session.
At the study session. All right. Is there a first? That was the first. Is there a second?
Second.
Okay. All in favor? I guess we'll take a roll call vote. Or is a voice vote okay?
Aye.
Why don't we do a roll call vote? Why not? Let's do that.
Commissioner Trosis?
Yes.
Commissioner Foster?
Yes.
Commissioner Phyllis?
Yes.
Commissioner Drawn?
Yes.
Motion carries.
Thank you.
So excited about our next presentation.
Okay. And with that set up, 12B, Brian Augusta, the Rent Control Board advocate and representative in Sacramento, will present a legislative report for the 2017 and 2018 regular session of the California Legislature. Hello.
Yeah.
Chairman and
Oh, hang on.
Can you hear me?
There you go.
All right,
Good.
now I'm on. Okay. So, as always, a pleasure to appear before you tonight. Usually I would be here earlier in the year, at the end of last year, actually, given that the legislature wrapped up its work in September, and we would have usually been here toward the end of the year to report on the actions of the legislature from the prior session. For a variety of scheduling reasons, we weren't able to pull that off until now. So hopefully what I'm about to report on will not feel too stale, given that it's a couple months old. But the upside is that I get to report on the latest and most immediate developments in Sacramento, which occurred this morning. So I'll start there. As many of you know, this morning, the Assembly Housing Committee held a hearing on AB 1506, which is Assemblymember Bloom's bill, also co-authored by Assembly Members Chu and Bonta, to repeal the Costa-Hawkins Act. It's a very simple bill. It does just that. But it's also obviously a very complex issue. And the hearing that began at 9 o'clock ended at around 1:30, all dedicated to just this one item. There were at least 1,000 people there from both sides of the issue, tenant advocates and others advocating in favor of the bill, and a number of landlord groups advocating in opposition to the bill, all of whom had an opportunity to say their view on the bill. It was a very rigorous debate. I think Mr. Bloom, I think, did an excellent job of presenting the case for the repeal of Costa-Hawkins, and supported by a number of witnesses who helped also make the case. Then there was quite a bit of discussion between members and supporters and opponents. I thought in the weeks leading up to this vote that when I appeared before you tonight, I would be telling you that the bill actually moved out of committee. I think everyone who's watching this on both sides of the issue does not expect that measure to get off the assembly floor this year. This is the beginning of a very long conversation about Costa-Hawkins. But I think there was a very reasonable opportunity for this to move out of its first committee. Unfortunately, the way in which the vote divided up, we had two members who were authors of the bill. So those folks were two, obviously, aye votes. We needed 4, or the measure needed 4. I can say the board supported the measure. We needed 4 votes. We had the 2 authors plus Assemblymember Stone from the Central Coast, who was sitting in for that day, and he was an aye vote. We knew that going in. And then there were 2 members, Assemblymember Wood, who represents the northern portion of the Assembly districts, so sort of up near Humboldt County, and then Assemblymember Chow, who's from down this way, Monterey Park and Arcadia. Both of those members, after a lot of debate and a lot of discussion, indicated that they wanted to see a measure that, rather than a strict or a full repeal, that they want to see something less than a full repeal. And they wanted to see more discussion and more debate and more compromise before they were willing to support it. And so both members abstained. And with that, and the 2 remaining members, Republican members, voting no, the bill failed in committee. The author did not seek reconsideration, which would have been an option and would have given him one more opportunity to hear the bill this year. That probably would have been fruitless anyway. So that bill is dead for this year. Now, something new could be introduced. The introduction deadline is weeks away, and a similar measure could be introduced again this session. Where a lot of people are turning their attention is to a ballot measure that's circulating that would put the same repeal on the November 2018 ballot statewide, and put the issue to the voters. So, from the perspective of the board, and which voted to support 1506, I think it was a very it was useful to have this public debate. I think a lot of the important issues around the impact of Costa-Hawkins and vacancy decontrol in particular, and its impact on renters in cities like Santa Monica. I think that was elevated. There's obviously a lot more work to be done to educate members of the public and the elected officials about the issue, and I think this will be a long debate, maybe something we'll see in the November ballot. But I think regardless of the outcome, it was a very fruitful discussion and very long discussion this morning. And I think it also, if you watched any of it on TV, illustrated the strong feelings on both sides of the issue about this proposal. So that's the most up-to-date rent control news from Sacramento that I have, more than anyone has. And if there are no questions or comments on that, what I'd like to do is just walk through some of the highlights of the report to update you on what we did last year.
Okay. Commissioner Foster has a question on that item.
Sure.
Hello. Thank you, Mr. Augusta, for that wonderful presentation on that part of it. Are there any updates on the court cases in the jurisdictions that had previously passed rent control that are
right? There were. Yes, although I don't have them at my fingertips, but there were challenges to the two measures that voters enacted last year. Both of those did not go the way of the plaintiffs, which were, these cases were brought by the landlord groups, which were challenging rent control. And I don't know that current disposition, your council may, but I think all of those cases have been resolved at this point, I believe. Is that correct? Yeah. So, and those, as I understand it, those challenges were to the substance of the rent control ordinance itself, and so many of those questions have already been settled. So it was a sort of a pro forma challenge by the opponents of rent control who just wanted to have one more bite at the apple.
Any other questions, Commissioner Foster, on that item?
No, they both dismissed their cases after they lost. They had to appeal. Yeah, for Richmond and Mountain View. That's what. Yeah.
Okay, wait a minute. Hang on a sec. Is there any more questions on this item, Commissioner Foster? No. Mr. Augusta. Okay. Commissioner Torosis, you had questions regarding this.
Yeah, can I ask about a current bill? Am I allowed to ask about that now?
He was going to give it.
Okay, I'll wait till he gives the report.
Go ahead.
Oh, we're all waiting with bated breath to know which one that is. I hope I cover it. I wish I could have come with better news given the board's position on 1506, but we do have a lot of good news on some measures from last year. Probably the biggest bit of news from last year's session is that the legislature really took seriously the affordable housing crisis in this state. And as a result of a lot of work from leaders in both houses and the governor, the legislature passed and the governor signed a 15-bill housing package, which has been fairly well reported on, but I would hit a few highlights that I know are of interest to the commissioners. One of them was the enactment of AB 1505, also by Assemblymember Bloom, which effectively overturns the Palmer decision, which had interpreted Costa-Hawkins as prohibiting the application of local inclusionary ordinances to rental housing. And this is something that proponents of of inclusionary have long sought to overturn that decision and restore the law to what it had long been, which was to permit the application of inclusionary to rental and for sale. 1505 finally settles that question with some minor compromises that really, I think, as a practical matter, don't have much of an impact on the local application of inclusionary zoning measures. So that was big news and gives back a tool that many local governments have used to try to expand affordable housing. On that same vein, on funding for affordable housing, another long sought measure which was embodied in SB 2 this year was an ongoing source of funding for affordable housing, which SB 2 establishes a $75 fee on certain recorded documents that will provide ongoing revenue to support affordable housing development, sort of a state housing trust fund, if you will. In the final analysis, the bill, in order to line up the votes, because it was a 2/3 vote bill, changed quite a bit from what the bill had originally proposed, and a good portion of the money is going, rather than being at the state and filling some of the existing state funding programs, most of the money is going to go to go to local governments for that purpose. So there's a lot that's going to be happening over this year and next to implement that and to shape what does that funding look like. But important infusion of funding for affordable housing. Related to that, SB3 will put on the November 2018 ballot a $4 billion bond for affordable housing, $3 billion of which will be for a variety of affordable housing programs, and $100 billion of which will go to veterans housing. So that will be before the voters, in November. I'm sorry?
Sorry, I think you said $100 billion. I think you meant $1 billion.
$1 billion, yes, thank you. Can't get those right. Okay, so $1 billion, $4 billion total. Yeah, yes. I think people are cautiously optimistic that the voters will support it. They have supported these bonds in the past. And so that would provide a great infusion of money. Another closely watched bill was SB 35, which many were concerned. This is a bill that would streamline the approval of new market rate and affordable development. There's a lot of discussion about that bill. I won't get into all the details. Happy to talk more if people have questions. I think in the bill that emerged at the other end is, I think it's yet to be seen whether it has the broad application that many were worried about, that it might streamline housing in a way that would further exacerbate displacement and rising rents. And so it will be interesting to see how that bill, which provides some streamlining of market rate development that includes affordable, what its practical impacts will be. And in addition, the legislature did a bunch of things around planning for housing, around housing element law, and some of the sort of front-end planning that local governments do to encourage affordable housing, and then added some additional enforcement to that. So I think all really important developments on some long-sought improvements on affordable housing. There were also some landlord-tenant tenant bills that were introduced this year, but the housing bill package was mostly focused last year on production, and that's one of the things that, as we talk about bills for next year, I think the legislature is likely to focus, and today's hearing on 1506 is an indication of that, of the pieces that weren't really addressed in this housing package, which is what do we do in terms of immediate relief for tenants. One bill that did provide some relief is AB 291, which is discussed, as all these are, in your packet. But this bill responded to potential increasing pressure on immigrant communities and tenants who are undocumented or perceived to be undocumented, and providing additional protections from eviction and harassment for tenants, also signed by the governor. There were a couple of other rent control related measures that were introduced this year and didn't move forward. One was AB 423 by Bonta, which would have added an exemption to the Ellis Act for SROs that currently exist in some cities, including San Francisco, Los Angeles, and San Jose. That bill failed on the floor. And then there was also a bill on expanding the notice provisions in Ellis Act by Mr. Bloom that didn't move forward this year. So in the interest of time, and I know there may be some questions, I'll stop there. There are a few others discussed in our report. If you want to ask questions about those or read back through the report, those will detail those.
Thank you very much. I do have a request to speak from Commissioner Troseth.
First of all, I wanted to thank you for coming here, especially after such an intense and long day. I can't even imagine how exhausted you must be. And also, I don't think you're giving yourself enough credit. I think that you had a really big part to play in the passage of all of these bills. I mean, I know that I'm not in Sacramento, but I can certainly say from our partners around this county, I think, you know, your help in making sure that these cross the finish line was really instrumental. So thank you for all of your hard work. We really appreciate it and appreciate you and your staff. of course, I think I would be remiss if I didn't say, especially since we dealt with this issue earlier, of course I would support, and I hope this board would support, any sort of bill that would extend Ellis notice provisions. I think we frequently see that, and I think the current notice provisions aren't sufficient. I just had a couple of quick questions. And I don't know how relevant it is for Santa Monica, because I don't know that we have a lot of at-risk properties here that are under like HUD covenants. But can you talk to us at all about about AB 1521, the preservation bill,
Yeah.
and how that's being implemented?
Thank you for raising that. That was actually in my notes, and then I ended up skipping over it.
Well, I care,
Which is
so.
not, yeah, and which is not a testament to its importance. It's very important part of the housing package, which state law includes some provisions that are aimed at helping to preserve affordable subsidized housing that's at risk of converting to market rate because the regulatory period or the subsidies attached to them are expiring. And the law has been on the books for a number of years. It's had limited effect. In some cases, it has led to preservation. But advocates have been wanting to strengthen the law for a number of years to really try to create some additional leverage to preserve these units. And one of the things that 1521 does is give the ability for what we call a preservation purchaser, picture a nonprofit affordable housing development organization, coming in and purchasing a property that would otherwise be sold and converted to market rate or converted to another use. So 1521 expands those obligations to provide that preservation purchaser an opportunity to match a market offer. So if it is for sale and they make essentially a market offer, you have to sell it to the preservation purchaser. It also expands the notice provisions to put the notice 3 years out prior to the loss of these subsidies. Requires additional noticing to local governments and to the State Department of Housing and the Housing Authority, so that there's additional public understanding that this may convert, and then give some additional standing to tenants to challenge the lack of those notices. So that is another bill that there's going to be some important implementation this year that HCD and others need to do to really make that happen. But we hope will help preserve the tens of thousands of units that are at risk of being lost in California.
And could the city of Santa Monica be a registered preservation purchaser, and then and then put help to preserve the buildings and
Probably
help them remain under
some
covenant
other entity like Community Corp.
Yeah, I just want to make sure that the city is fully aware of that. Okay. And then with SB2, first of all, I was very happy to see, not that it was a surprise, but that in the governor's budget, there was funding for SB2 and SB3, presuming that SB3 passes. Yeah. But are we involved in the discussions as to how SB2 is being implemented such that we can ensure that the money is being apportioned fairly and equitably from a regional perspective, so that regions who are in need and with per population needs of this region are getting an equitable share of the funding?
Well, the way in which the legislature decided to apportion those funds that are going to local governments is to use the formula that the federal government uses to distribute the Community Development Block Grant Program, which is it's apportioned by population size, essentially. There's a more complex formula, but that's part of it, and poverty rates. So larger jurisdictions will get more, smaller jurisdictions will get less. And anyone who was interested could kind of look at how the CDBG money is distributed and get a sense of how this money will be distributed. The one difference, to your point, is that every local government will get, regardless of size, will get some portion. That may mean $10,000 or $15,000 or $25,000 a year. So a big question is, how do we make sure that money is meaningful? Because in some jurisdictions that won't be enough to do something with. So how do you make sure we put those dollars to work? So that's one thing that housing advocates are looking at in terms of your question.
Okay, and is that something that we need to be in the conversation on? Or you're in the conversation for us?
I'm certainly in that conversation.
Great.
I think it's a question of, is it the rent board, is it the city council?
Right,
but,
of course.
Yeah.
Yeah. And then finally, pertaining to current legislation, obviously, I'm sure you know about SB 827 that Senator Wiener introduced.
Yes.
And I know that it's raised a lot of talk in Southern California, especially because we have a lot of these transit-rich areas that would be effectively lost to the local jurisdiction for zoning. Do you have any, thoughts on that and
well,
kind of advice?
I would just say that it's very early in the session. It's January. That bill probably won't get a hearing until late March or April. There's, I think, going to be a lot of discussion about how do you accomplish that policy of increasing density around transit without also furthering displacement and some of the other effects of gentrification that may occur. So I think that debate we're already hearing rumblings of that debate, so I think that's going to be a central part of that conversation. So I will happily keep the board abreast of it as that conversation develops, but I will certainly
Yeah,
be involved in
definitely
the
would love to, especially because we have our metro line that has newly come to Santa Monica, and if we're talking about everything that's within a half mile of transit, I want to make sure that we're preserving our rent-controlled housing stock here, and we're doing this in a way that's sensible to displacement pressures. So
Absolutely.
Thanks.
Yep.
That's it for me.
Okay, anyone else have questions for Mr. Augusta? Okay, thank you very much
Thank
for
you
making
very
the
much.
trip.
Thank
we
you.
really appreciate it.
Are you flying back tonight or tomorrow, Brian?
Tomorrow. I don't know if I could get a
Sleep
flight.
tight.
Sacramento doesn't have late
Sleeping.
flights.
All right, with that, moving on to item 12C, the election of the chairperson and the vice chairperson for this upcoming year. Before we do that, I just want to say, I don't know why I get emotional. I'm such a wimpy guy. I know, it's going so fast. All right, please bear with me as I go through this. Well, it's been an honor and a privilege to serve as the chair this year. Why am I doing this? Okay, pinch. It's been an honor and a privilege to serve as chair this year, and I thank you all for the patience that you've given me. As I've stumbled along through my notes, thank you, Lonnie, for my cheat sheets to make it through a meeting. I couldn't have done it not once without these notes, so I appreciate that. And also thank you for the indulging me in my pontifications every once in a while, and also for respecting the position of chair. Also, I'd want to say that it has always been my goal to run a smooth meeting, to allow an open flow of ideas and communication, with the hope of coming to well-informed decisions. I really don't know why I am getting so emotional. Anyway, it is a privilege to work with my fellow commissioners who have proven to be committed, dedicated civil servants for our community. And as we move through the challenges and the great opportunities that are in front of us, I am excited to see what this new year will bring. With that, it is my great pleasure to nominate Commissioner Foster as the chair and at the same time Commissioner Chorosis as the vice chair.
I'll second that.
Okay. Okay, there's a first and a second. Do we have to have a roll call vote or... Okay, we'll do it by acclamation. All in favor? Aye. All right. Good luck to y'all. And this will be the last item. The last time I'll do this, I'm gonna hit this because I don't really do it, but what the heck. Our next meeting will be January 25th at 7 p.m. here in Council Chambers. Please come to discuss these items that are very important, as you have heard. And for those folks who haven't come in and spoken yet, please speak
Before you hit the
at the
gavel.
meeting. Okay, before I hit the gavel.
I just want to thank you for your leadership over the last year. You've done an excellent job. It's not always easy to be the chair of this meeting, and we recognize that. And I want to thank you very much for the excellent leadership that you provided.
Yeah, I want to second it, actually. Steve, you've been an absolutely fantastic chair. It has not been easy, and you have done it with unparalleled grace. And it's really nice to see your leadership. So thank you for all the service that you've given. I mean, it's amazing, and we're really, really lucky to have you.
Thank you.
I want to give you a little hug.
All right. With that, we will see you at the next meeting. This meeting is. Oh, wait. Do I need a motion? I guess I need a motion to adjourn. Move to adjourn.
Second.
First and a second. All in favor?
Aye.
This meeting is adjourned.
Why am I doing this?
It's ridiculous.
Thank you for your
I'm being so ridiculous.
You're going to be on here for a long time. You're not going anywhere.
I got another year.
Yeah.
What a joke.
I'll do the same thing. I get tears.
All right.
Yes,
Last
thank
time.
you.
For the
We
last
really
time.
appreciate you coming.